Act PL 1975, Chapter 231, adequate notice of this regular meeting of the Board of Adjustment of the Township of Franklin has been provided. Would you call the roll, please?
Mr. Betterbid, he asked to be excused. He's out of state. Ms. Grauman. Donald Johnson. Bruce McCracken.
Here.
Mr. Rich.
Yes.
Mr. Shepherd.
Here.
Mr. Caldwell.
Here.
Mr. Rosenthal.
Here.
Mr. Reese.
Yep.
Mr. Pagala.
Here.
Chairman Thomas.
Here. We have minutes of the regular meeting, February 5th, 2015.
I move we accept it.
Second.
Mr. McCracken.
Yes.
Mr. Shepherd.
Yes.
Mr. Caldwell.
Yes.
Mr. Rosenthal.
Yes.
Mr. Reese.
Yes.
Chairman Thomas.
Yes. Resolutions, Genesis FBCCDC, Somerset Senior Housing, ZBA 14-00014.
I'll move it.
I
Second.
second.
Mr. McCracken.
Yes.
Mr. Rich.
Yes.
Mr. Shepherd.
Yes.
Mr. Rosenthal.
Yes.
Mr. Pagala.
Yes.
Chairman Thomas.
Yes. Miller, ZBA 14-00011.
I'll move it. I'll second.
You get a second?
Second.
Mr. Rich.
Yes.
Mr. Shepherd.
Yes.
Mr. Pagala.
Yes.
Chairman Thomas.
Yes. And then Wolf, ZBA 14-00001, an extension of time.
Move the extension of time.
Second.
Mr. Caldwell.
Yes.
Mr. Rosenthal.
Yes.
Mr. Reese.
Yes.
Chairman Thomas.
Yes. In the discussion section tonight, we have a voucher for Mr. Bradshaw, April retainer, $865.
Move the voucher.
All right, all in favor?
Aye.
Opposed? Motion passed. Under the hearing section, McCoulis Choma, ZAB 15-00004. This is a hardship variance in which the applicant is seeking approval on an addition at 217 Adams Street, Somerset, Block 550, lots 40 to 45 in the R10 zone. This is carried to May 7th, 2015, with no further notification. Now, are we ready to proceed?
Yes.
Simply Yoga, ZBA 14-00018, use variance and site plan in which the applicant is proposing a yoga studio and a single-family dwelling at 24 Sycamore Place, Kingston, Block 5.02, Lot 152.04, in an R20 zone. This has been carried from March 5th without any further notification needed, and as probably everyone here knows, it's a continuation, probably the fourth hearing.
Good evening, Mr. Chairman, members of the board. Peter Lanford appearing on behalf of the applicant. Your comments, Mr. Chairman, are almost 100% correct. This is the fourth hearing. However, the last hearing was on March 19th because the March 5th hearing got snowed out. So just to refresh the board's recollection very briefly before I go into my witnesses, this application started on January 8th of this year. At that time, we presented the testimony of the architect who described both the condition of the existing dwelling, which is going to be rehabbed, and if the board were to grant the variance, be used as the studio, and then also the single-family dwelling that would be resided in by the applicant to the rear of the building. The second hearing took place on February 5th of this year. The applicant testified about the studio, the hours of operation, the number of people attending, and then we also had the testimony of the site engineer, Mr. Ardman, who reviewed the site plan, parking, lighting, stormwater management, all of the relevant issues, and dealt with the staff reports. We then did return on March 19th. At that time, Mr. Ardman presented a revised plan where we relocated the parking further away from the single-family dwellings that front along Laurel Avenue and had one row of parking as a revision. And also as part of that plan, we removed the sign that was proposed as part of the application. In addition, Mr. Pliniak testified. He is the traffic consultant who is an employee of Dolan and Dean. Talked about counts, trip generation, and things of that nature. At that point, there were questions raised as to basically the timing between the classes, whether there was enough time for people to get in and out of the classes, how the counts were done, and the meeting was adjourned at that time. Also at that time, we did agree at that last meeting, in addition to removing the sign, that all classes would be at least separated by a half hour in time to allow for people to come and to go. In addition, in talking about restrictions, because the architect testified as to the potential of 30-plus mats being available in the yoga studio, we had indicated that we had provided to you counts for the last 2 years and would agree to cap the limit of students during the week to 16 and on the weekends to 28 at any one given class. And that's where we left off. So that's the Reader's Digest version of the last 3 months. I would like to call as my first witness this evening, Ms. Dolan.
Solemnly swear or affirm to tell the whole truth, nothing but the truth?
I do.
Okay.
Ms. Dolan, what is your occupation?
I'm a licensed engineer, sorry, it was a fast drive. A traffic engineer, professional engineer registered in New Jersey, New York, Pennsylvania, and Delaware.
Is that on?
Is your mic on?
I think.
It's on, it's making noise. No, it's not. Just killed it.
How about now?
Yeah, that's,
It's on?
yeah.
Okay.
Okay.
You wore it out last night, Pete.
Ms. Dolan, the primary scope of your business is in traffic engineering, traffic design,
That's correct.
and can you give the board the benefit of your educational and professional background?
A Bachelor of Science degree in Civil Engineering from Rutgers University. I'm a licensed professional engineer registered in New Jersey. For the past, I think, 28 years, I've focused in the areas of traffic and transportation engineering. I've appeared in Franklin many times and in other municipalities throughout the
Okay,
state.
we can
Thank you.
accept that as.
Okay.
correct.
And as I indicated in my statements earlier, your associate, Mr. Pliniak, testified at the last meeting.
Yes.
The traffic report that was submitted in conjunction with the application, the original report dated October 30th, 2014, was prepared under your direction. Is that correct?
That's also correct.
Okay,
Yes.
and that's the report that Mr. Pliniak testified to at the last hearing?
Yes.
Okay, when the board raised the questions about the people coming in and out and the timing and the gaps between the sessions, did you do an additional analysis?
We did, and it's summarized in a letter dated March 31, 2015.
Okay, and that letter dated March 31, 2015 was submitted to the board prior to this hearing?
That's my understanding,
Okay.
yes.
And in order to prepare that letter, what did you do?
Well, we first met with the applicant and went through the list of stipulations that you just talked about with the board in terms of the class size, maximum number of students at any one class, the class duration, and most importantly, the time between classes. So with that information, we then summarized the arrival and departure patterns associated with maximum class attendance on a weekday and maximum class attendance on a weekend. So we assumed, as you had said, that 16 people would attend the successive classes during the weekday evening. So 16, and we assumed that each student would drive their own vehicle. So 16 cars would enter and 16 cars would exit over the course of about a half-hour period. And we did the same thing for a Saturday with a half-hour break in between classes and maximum attendance of 28 students per class, so that would be 28 people driving their own car, entering for a class to begin, and 28 cars exiting for the end of a class. And again, that would be over a half-hour period. So that would be the maximum concentration of activity if all classes were attended at maximum capacity and if all students drove their own vehicles. At the last meeting, there was talk about shared ridership because often a couple will come together, friends will come together, parents and their children may come together, and a ride-sharing factor of 1.5 people for each vehicle was assumed as a separate analysis, which would bring the numbers down a little bit from 32 total driveway movements on the weekday evening to 22. So that would be 11 in and 11 out. And similarly, on the Saturday, the peak concentration would be reduced from 56 movements to 38. And so we broke that down into how the people would arrive and depart in each 5-minute section of that half hour between classes. So the analysis that's been submitted in this latest letter looks at maximum capacity, single students driving their own vehicle, and that turns into a maximum of 56 trips or driveway movements during the busiest time on a weekend. That level of trip activity is not considered significant. The Institute of Transportation Engineers and our State Highway Access Management Codes, they define significant as 100 or more trips in an hour. We'd be looking at 56 as an absolute maximum on a Saturday or Sunday, and 32 is an absolute maximum. So that's not the type of number that's going to create a negative impact, and it's certainly, while it's a little bit higher than activity associated with all single-family homes, which would be the permitted development here, in either case, it's not considered significant. It's not enough traffic to create a negative impact. And certainly, with the plan that's been developed, the traffic isn't going to be recirculating. There will be enough parking on site to accommodate these maximum demands, and there wouldn't be an overflow into the onto the street. And if there were also some activity generated by the house that's proposed as part of this development, one vehicle may be entering or exiting during that busy half hour. So again, we're not at a significant level. The traffic can arrive and depart during that overlap period. And in my opinion, this is not a traffic impact issue. I think it's more of a site design layout and making sure we've got enough parking to accommodate the maximum attendance levels. But when we recognize that not each student does drive their own vehicle, I believe there's certainly enough capacity on the roadway system as well as on the proposed site plan to accommodate the parking demands as well as the trips that will be generated.
Okay, and with the redesign of the parking lot that we presented at the last hearing, we basically have 24 parking spaces plus 4 attributed to the dwelling, so there's a total of 28.
That's right.
And those 4 that are attributed to the dwelling can actually be used by the students if necessary, is that correct?
They could, and that area also provides a comfortable turnaround, and there's that hatched area so that if someone had to momentarily wait for another space, they could do so without, again, backing out onto the public right-of-way. And then also the driveway design itself has capacity to hold vehicles. So I think it's a very well-designed site for this proposed use.
Okay. And again, there were 2 issues that the board was concerned about. One is obviously the attendees coming and going and making sure there's adequate parking available if some people were earlier in arriving or a little bit slower in leaving, and in your opinion, that with the parking that we have provided as proposed, there's more than adequate on-site parking, is that correct?
Yes, that's my opinion.
Okay, and the second issue that the board had a concern about was the impact on the road system of these vehicles, and the main focus was the evening peak hour traffic. In the original report that you submitted, it indicated that there was a fairly significant amount of traffic on Laurel Avenue, is that correct?
Yes.
And can you indicate to the board basically how many vehicles during the evening peak hour travel along Laurel Avenue?
Let me just get to that sheet. From 5 to 6 o'clock, the total two-way flow approaches about 1,000. It was 800 plus during the evening peak hour, and then it drops during the evening crossover period that we were looking at. It drops down to about 400 to 500.
Okay, so from 5 to 6, which is part of, well, first of all, let me back up. What is considered the peak hour?
The peak hour is about 5 to 6 o'clock.
Okay.
The peak hour associated with high commute activity, and I believe during that that hour is when we noticed more queuing on Laurel Avenue on the approach to 27 at the signal. But then in the subsequent hour, 6 to 7, the numbers dropped off, and then from 7 to 8, the numbers dropped off substantially. So the peak hour we recorded was 5 to 6 p.m.
Okay, and you indicated at that peak hour of 5 to 6 p.m., there were approximately 1,000 vehicles.
Yeah, it was just under 800, actually.
All right, under
Yeah.
800 vehicles. And basically, with respect to the operation at this facility, the students during that peak hour would be coming to the facility because there will be a class starting at 5:30, correct?
Yes.
So generally, there would be nobody leaving, people would be coming.
Yes.
And we gave the board the empirical numbers, and historically, it's been 12 or less over the last couple of years, but for discussion purposes, we are saying that there are 16 people that are going to show up.
And the prior analysis actually looked at a total of 40 movements.
Okay. And if we take those movements in your analysis, what effect or what impact would those vehicles that are coming to this facility have on the level of service of Laurel Avenue and the intersection of Laurel and Sycamore?
A minimal impact. We had assumed that all the traffic would arrive and depart through Laurel Avenue. I know there was some discussion about possibly making a prohibition so that the cars only come to and from Laurel Avenue. That's the way we analyze it, and there's a nominal impact. The intersection will continue to operate at acceptable levels of service, even with the higher traffic volumes that we looked at in the original analysis.
Okay. Now, you indicated when you did your analysis, you accounted for basically 16 vehicles coming for each session, 16 vehicles going for each session, even though logically it probably doesn't work that way, correct?
Right, because you would expect there to be some ride sharing, and you would also not expect to have maximum attendance at every class.
Okay. And there is also, in traffic engineering, something known as pass-by traffic, pass-through traffic. Is that correct?
That's correct, too, yes.
And what's that?
Well, someone, in this particular case, if they were leaving work and wanted to go to a class right from work, maybe they're already on Laurel Avenue and they're diverted into the yoga studio. So there may be a small credit for that as well. But as I said, we didn't use the 16, we used 20, and we assumed all of that traffic arriving and departing via Laurel Avenue, with no credit for pass-by, no credit for ride sharing.
Thank you. I have no further questions.
Any board questions?
I have a couple. In the beginning, well, toward the middle, Ms. Dolan, you referred to something as queuing. What is that? You said there was queuing on Laurel Avenue.
Oh, vehicles lining up to wait to get processed through the traffic signal at 27.
Okay, and did you yourself do the counts on this particular intersection?
No.
So what you're doing is you're looking at the numbers that you have and coming to the conclusion that there was queuing at what point? Was there queuing only at 5 o'clock?
Let me try and find those notes for you. 5:45 to 6 p.m., traffic backed up on southbound Laurel, blocked Sycamore for a few minutes off and on, never passed Sycamore by one or two cars.
So in other words, the notes in your testimony, the notes in your traffic study there show that even at the 5 to 6 hour, the traffic backed up only as far as Sycamore and no further down Laurel Avenue toward Route 518. Is that correct?
The note says a couple of vehicles passed
A
Sycamore.
couple of vehicles.
Right.
So it would surprise you to find out that on occasion at that particular hour, the traffic runs back all the way to where Laurel Avenue separates from the extension of Canal Road.
It may. I haven't traveled through that area in peak evening in quite some time, but
Okay.
I know because of the cut-through activity that is in that neighborhood, I know that there are backups.
Right. All right. And what is the traffic volume at 7:30? What does the report say about that?
The 7 to 8 o'clock hour, the two-way volume on Laurel drops to 433.
Okay, so that means during that hour, a total of 433 cars moved in two directions or one direction?
That's two directions.
That's
on
two
Laurel.
directions. Okay, and was there any queuing in the hour from 7 o'clock to 8 o'clock according to your traffic study?
Not that was impacting the Sycamore Avenue intersection.
Okay, so that in the hour from 7 o'clock to 8 o'clock, your traffic study shows that there was no backup on Laurel Avenue from the traffic light back past Sycamore. So people could have exited without any difficulty onto Laurel Avenue from Sycamore at that time.
Yes.
Okay. And wait, tell me, what was the volume of traffic at 9 o'clock in the morning on, actually, better time is 10:30 in the morning on that Saturday?
We did not perform any Saturday counts. I don't have any data on Saturday.
Okay, so then, in other words, we don't know from your traffic study what the amount of traffic is on Laurel Avenue on the weekend?
That's correct.
Okay. I guess that's all the questions I have.
I have a couple questions. You said in the 1.5 hour period on Saturday that you used, when you used the 28 people, it generated 56 trips in a half hour,
Correct.
and that's less than 100, so that's considered insignificant. Okay, I
Correct.
listened to your report on Laurel Avenue, and you started by giving the conditions of Laurel Avenue before you said anything about the effect that this facility would have on it. Did you do a study on Sycamore showing what the conditions traffic-wise are on Sycamore without this facility?
Well, we have the counts that were performed that show the volumes traveling on Sycamore, and it's a handful of vehicles. There's not much traffic during each of the hours that we inventoried.
Say during the same hour we're talking about.
The hour that we used for analysis, we had a total two-way flow on Sycamore of 4 vehicles. So that was, inbound and outbound at Laurel Avenue,
All right,
from
then
6:30 to 7:30.
my real question would be then, if the number is 4, and we're talking about 56, how's that insignificant? Because you're taking 4 and 10, 12 times more traffic volume is going to be put on the street. It may work in the traffic manual tables, but how can that be insignificant?
Mr.
Well-
Thomas, again, I think we went into this. The number she was talking about with the 4 vehicles, I assume was the evening peak hour traffic
That was the analysis
Right.
hour, right.
at evening. The 56 is the 28 and 28 on a Saturday. So you can't, the number on the weekday that you would have to use is 32, which is the maximum attendance. So you can't use the 56 number, which is the Saturday number, and then apply it to the weekend number, to the weekday numbers.
Apply the number from the facility to any hour of the day, night or week
Okay.
on Sycamore that you want to, I can't imagine that it's going to, I mean, even if the number were 56 now, and you're going to add 56, to me, that's a 100% increase.
Sure, but the fact is that the roadway is underutilized in that regard.
Well,
I'm not suggesting
You're making a
that
comment
there's-
that it's underutilized. Is it underutilized, or is it being utilized as it's zoned?
Well, again, we counted the volume that's there. I'm not disputing that we would add several more cars than exist during these transition periods between
And-
classes. But it's not, just because it's more traffic than is there now, doesn't mean it won't work.
I understand. There's always the old, thing where anything you build is going to contribute more than what's there presently. But we're talking about, you're not convincing me that potentially more than 100% increase rises to a little bit higher level than being insignificant, even though the traffic manual says it's under 100, so it's not supposed to be significant.
Right, and so in this case, it would be noticeable certainly to people who are familiar with that road, who reside on that road. That certainly is going to be a noticeable impact, but it's not going to be a negative traffic impact, because the capacity is available to accommodate the turning movements into and out of this proposed facility.
Okay, you mentioned in your study the possibility in terms of Laurel Avenue of cut-throughs, people taking shortcuts. Is any of that accounted for from Laurel to Sycamore on through to 27 through the neighborhood? Since the intersection is a problematic intersection at Laurel Avenue, what does the traffic manual say is going to happen in that case for people trying to avoid it?
Well, I had been involved in another study where we counted Shaw Drive, which is connecting to Union and this area that we're studying, and it was apparent through the various counts that I had performed and reviewed that there's an existing cut-through problem, and I think there's signage out there that prohibits certain movements just to discourage that. So if that is an existing problem, people taking Laurel to Union to Shaw to get to 27 to beat the light because we know there's queuing that exists back to Sycamore at times, that's an existing problem that, as I said, is evident through the traffic counts and the observations that we made. Whether this property is developed with homes or a yoga studio and a house, that's not going to change that cut-through pattern. I don't believe that this is something that's going to generate a cut-through problem. I think that's an evident problem that exists currently. I believe that the applicant had offered, or it was discussed, to possibly sign the proposed driveway so that people wouldn't turn into the neighborhood but would be forced out to Laurel Avenue. But whether or not people are already cutting through and then decide to use the yoga studio, that would be, as I said, an existing condition, but I don't think it has anything to do with the development of this property. I think it has to do with the fact that 27 and Laurel is limited in capacity, and people don't want to wait for the light.
Okay, any other questions from?
I have a couple more. You spurred me on. It says, and I'm kind of focused on what Mr. Thomas was talking about. If you go to the last paragraph of your letter, before that final sentence, it says, using the data of the 6 homes would generate approximately 4 trips during the time intervals being discussed. And what you were doing, you were using the hour of the weekday evening hour. Is that what you were using? I'm trying to get an apple and an apple gum.
Sure, right. I did. I used the same roughly 6 to 7 o'clock hour for ITE single-family homes I generated the trips, and then I applied that hours factor to it, and that's where I came up with, I believe it was 8, so I cut it in half for the half hour.
Okay, so then the difference is 4 trips, or is it, what's the comparator there? Is it
Well, it would
the
be,
20?
it would be on a weekday evening,
Yeah.
it would be 32 if you had 2 classes attended at 100% with every student driving themselves.
Okay, so then the comparison is 4 and 32, right?
What's that?
Right?
4 and 32.
Okay, now, you said about that, you said it would not have a negative traffic impact to have the 32 trips instead of the 4 trips. Does that mean that it wouldn't have a negative impact on the environment in the neighborhood? Or does it mean that it wouldn't change the level of service on the road? In other words, it wouldn't change it from an A to a C.
That's right. It's not going to change those operational characteristics, and the driveway intersection with Sycamore would operate at acceptable levels as well. So there is capacity to accommodate those movements into and out of the site, and there is, so from the reading of that paragraph, my comment is there is no negative traffic impact because the capacity is available to accommodate those turning movements in and out of the site.
Okay, and in and out of the site. Now, what happens when those, well, it'd be half of 32, because only half of them would be leaving, but what happens when those people would get to the intersection of Laurel and Sycamore? Would there be a deterioration in the traffic service at that intersection?
We calculated acceptable level of service B on the Laurel approach to, on the Sycamore approach to Laurel. So no, there would not be a negative impact.
So it would go from an A to a B?
Don't know if I have that. Just a second.
I've been
I
doing
think it
this a long
stays,
time.
I think it stays at a B. Yeah, it stays at a B for, and again, that analysis is based on 20 cars, not 16, leaving the site.
Okay, and that is also based upon traffic data for that hour that was not collected by you, but by somebody at your request?
That's correct.
Okay.
We counted consistently for a few hours, and the analysis hour is 6:30 to 7:30. So it's after the peak when the classes would be turning over.
Okay, yep, that's all the questions I have.
Okay.
Any other board questions?
Just the category of the Laurel is, it's a rural road, and it changes from rural to, I guess, collector at some point?
I'm not sure. I think it's a county road, but I don't know how, if it's classified beyond that, and I don't think that I've got anything specific other than
It's just 2
Somerset
lanes, right?
County roadway with 35 mile per hour and 2 lanes.
And how many cars get through the light on a change of light?
We didn't count the light. We counted specifically at Laurel
Laurel.
and Sycamore. And during that time, as noted, there was a period of about 15 minutes when the cues from the light were reaching our location. So I don't have any data on the intersection that's signalized. We counted this specific location only.
Okay.
Other questions?
Yeah, a few questions, Mr. Chairman. Some more questions on this term significant. In your testimony and in your report, you basically make the point that it falls well below what ITE, which is the Institute of Transportation Engineers, and the State Highway Access Management Code, if it's less than 100 trips per hour, it's considered not significant. Can you tell me what type of roads I think that term significant, I would think that's a relative term. you know what type of roads the ITE based that on? Was it
Well,
highways? Was it
it's
collectors?
it is a number that starts from the ITE's perspective. They recommend that a traffic study be performed when a site generates 100 or more trips in an hour, because that level of traffic generation can start to have a measurable impact, can start to change the levels of service at nearby intersections. So it's independent of the type of road. Our State Highway Access Management Code, of course, is written for our state highway system, but the same approach is taken when you have 100 or more trips for an access permit. You're obligated to perform a traffic study to determine what impact is felt at the adjacent intersections. So that would be, of course, applicable to state highways, but the ITE, as related to the performance of traffic studies, talks about all roads and all types of developments.
Okay, so the State Highway Access Code, so this is for if you're going to do some type of development on a state highway, once you're over a type of use that generates more than 100 trips per hour, you need to submit a traffic study.
If you have 100 or more trips at an intersection, then you have to study that intersection.
Okay. Is there any, for counties or municipalities, or is there any other rule of thumb for lower classification roads?
Again, not for the classification of roads, and the only more stringent ordinance that I'm familiar with is in Parsippany, and they want you to study 25 or more trips at an intersection. But again, that's independent of the roadway, and it would be applicable to any development within that municipality. So the same would be the ITE's recommendation. If you're developing in a residential neighborhood, you study the residential roads where there's 100 or more. If you're developing a commercial property on a busier highway, it's 100 trips that are to be analyzed wherever you have those 100 trips. So it really isn't based upon the roadway classification. It's that number of trips being added to an intersection is that's what they recommend you study, and that's what our DOT requires that we study.
Okay. Do you know the width of Sycamore?
I know it's
In front of the
varying, but it's maybe 20 feet in some areas. I don't know specifically.
Okay. At least in my report, and based on, I think, what the site plan indicates, it's commonly less than 20 feet in width and as narrow as 17 feet. What type of road would that be classified as?
A residential access road, maybe? I'm
Okay.
trying to think of the categories from residential site improvement standards. I think it would be a residential access.
Okay. Do you know, does 17 feet meet the minimum standard for a residential street?
I think that 20 is the minimum, but I'm not certain, 20 with no parking. So 17 is not necessarily what we consider a design standard. You know, if you can get 12 feet, 12-foot lanes, that would be 24, but a minimum is typically around 20.
Okay. So as a traffic engineer, if we have a road that's 17 feet in width, and it's expected to, there is a proposal to add, at least for certain periods of time, commercial level traffic, what would you recommend be done to the roadway?
Well, I don't know that we recommend that anything has to be done. Just because it's not 20 feet doesn't mean that it's a problem unless there has been a problem. And I'm not aware that there has been. The narrower width can keep speeds down. That can be a good thing, particularly in an area where cut-through is happening. You know, if the board or the engineering staff felt that an appropriate roadway width needed to be provided, I think that we would discuss it with the applicant. But I'm not of the opinion that we necessarily have to widen the road just because it is limited in certain areas. And again, the turnover that we're talking about, even at a maximum level, could be accommodated. And I know that nobody likes to hear there's not a lot of traffic on Sycamore, and this is going to put what some people perceive as a lot of traffic on Sycamore, but the capacity is there. So unless there's been a problem, or unless there's a condition that requires widening within the right-of-way, I don't see any reason why we would widen at this time.
So from a traffic, at least from a traffic engineering perspective, a 17-foot wide roadway can accommodate as much as 56 cars, 28 in each direction within a half-hour time period.
Given the volumes that are on the road now, it can handle it. That's a geometric issue, and again, that's an engineering issue. There are many times we get engineering reviews that will require a certain width, but again, we're talking about a maximum of 28 in, 28 out, which may or may not occur in a given period. And based upon, I keep saying it, the low volumes on Sycamore, there's certainly more than adequate capacity to accommodate those movements under existing conditions.
Okay. All right, thank you.
And just go back to the functional classification again. We have in our zoning canal preservation and canal road, and it comes along, and it's rural. And 6-acre zoning. There's and you come to a village, which is Kingston, and at some point, that rural road comes into it's still pretty, I don't know what the numbers are in the population there, but you got all of the commuters going through. So you have, it's kind of like South Middlebush Road, where everybody is going through what is preserved land and it's rural, but essentially you have an urban arterial taking commuters to work, but there's nothing on the sides, really. If you have somebody making a turn on South Middlebush, it blocks everything up and you got a big problem. And we haven't widened out those intersections or done anything, or the county hasn't. What we have down here is the same kind of situation, where people are commuting and they're using Laurel to get through Rocky Hill or wherever their turns are. It's certainly not an urban arterial. I mean, it's narrow and it's rural. Coming into a village that's expanded, but it's still a problem with the getting through the light, the number of cars get through. You could get more green time, but they probably won't give it to you.
Not on Laurel, no.
Not on Laurel.
Right.
They gave, and there's no, so the problem is still pretty real.
The problem on Laurel.
On Laurel,
Sure,
yeah.
and that leads to the cut-through activity. But the other thing, again, we could talk about the specifics of this design. If you look at, in concern of maybe Sycamore and its width or its activity, or holding up somebody who's trying to continue eastward on Sycamore, our driveway has an unimpeded length that will allow anybody on Sycamore to turn left or right in immediately. There's a distance of probably 6 or 8 cars before you encounter the first parking space. So we don't have any activity on the driveway that's going to preclude people from getting in, which again adds to the capacity aspect of this. I agree with you. Laurel Avenue, it's got a problem. Kingston has problems, and it's not just Laurel. It's it's that stretch and it's that historic area. But some of the people who are already traveling through this area, I think, would be coming to potentially this yoga studio. Certainly, we're looking to cater to an existing student population who is in this general area, and possibly to obtain more students from this area. So it's the type of thing, too, if this is an inconvenient location for certain times of the day or for certain people who reside elsewhere, you don't have to go to yoga here. I mean, the applicant doesn't want to hear that, but this is more of a selective trip, as opposed to I have to go down Laurel Avenue to get to work, as you were saying, a commuting trip. I'll go to yoga when it suits me, when it's peaceful on the roadway, as opposed to trying to get through Laurel and 27 to get here during peak hour, or choose a later class.
Good. Okay, I guess.
Any other questions?
Just one real quick, Mr. Lund. I do appreciate you explaining to us in a manner that I think, and whether the public disagrees with your opinion, in a manner I think we can all understand. So your basic opinion is that there will be an impact, but the overall impact is de minimis. Is that what your opinion is?
I would say that there will be an impact because of the things we've just discussed, because the volume on Sycamore is low. This will add traffic to Sycamore, but that added traffic can be accommodated from a capacity perspective. It will not create, in my opinion, a negative impact because the operational levels and the design of the driveway will allow traffic to freely enter and exit this property.
Thank you.
You're welcome.
You keep saying negative impact, and I think you're saying that from the point of view of a negative traffic impact, not a negative planner impact. You're not
Neighborhood
speaking as a
impact.
planner.
No, I'm speaking specifically as a traffic engineer, and my negative impact has to do with analysis, level of service, geometric operation. I fully respect that there may be an opinion here that there is a negative impact. I'll leave the planner to address that next, but from a traffic perspective, there is no negative capacity impact associated with the proposal.
Any other questions? All right, we will open to the public. This part of the hearing is still reserved for questions concerning the traffic report. So please keep your comments, keep your responses, or make them questions. We need your name.
Meredith Rogers, 17 Laurel Avenue. So I'm just wondering that 800 cars in that 5 to 6 p.m. period, is that an average over a couple of days that you took, or?
We counted one day, and then we looked at some data that DOT had, and I think they may have had about 3 days, and our data was comparable to theirs.
What was the date that you did the study?
Tuesday, September 4, 2014.
And you're aware that Labor Day on that year was September 1st, so that week might not be typical of a normal commuting week?
Well, we did look at the school calendar and, made sure that we were not on a half-day session or something like that. We knew, a lot of times the counts have to be done in order to meet a filing deadline, but as I said, in this case, we had a DOT count that we supplemented our counts with. So my data seemed to correlate with DOT's.
And what was the nature of the DOT analysis? When did they do that? Why did they do that?
They count all over the place and/or receive data from consultants and/or the county. I don't have their sheet with me, but in my notes it says they had a count from January 2013.
Okay, thank you very much.
You're welcome.
My name is Barry Pavlak. I live at 35 Laurel Avenue on the corner of Sycamore and Laurel. Has your firm ever done another traffic impact study for a shopping center business moving into a residential area?
Not that I can specifically recall. We've done many studies for shopping centers.
No, moving into a residential area?
Again, not that I can recall.
Have you ever heard of such a thing?
I'm sure I have, because I know I've represented use variance applications before where, for example, medical office, I know we've done a lot of those in residential areas.
We should assume that the accounts done on September 4th still stand, and that's really what you're basing your comments on. There's no new counts, in other words.
We've not performed any updates, no.
Okay. Now, when you measure a traffic impact for a business that has essentially 22 sessions during the week and look at a 2.5-hour window on one day, do you think that's a valid way of analyzing impact?
This question is often raised. We collect existing traffic volumes, and 1 day's worth of counts is considered acceptable in our traffic engineering world. And in this case, we, were able to rely on some other data that was available. The projections that we've developed, especially for this latest analysis that we just submitted a few weeks ago, have all been based upon the proceedings here and the existing operation, with now a limitation on 16 students weekday and 28 weekend.
I'll let the board decide whether this is testifying or not. But a company that's moving into a brand-new facility,
This a question?
yes, it is.
Okay.
Should not be expected to reduce the number of available sessions to its customers. Would you agree with that?
I'm sorry, I don't understand the question.
Well, currently, there are 22 classes a week in the shopping center. There's no reason to expect there to be less than 22 sessions a week in this new facility, is there?
I don't know that count, and I don't know operationally. I would think that they're moving their operation here, so I would imagine it would be
Well, if we
comparable.
can make that assumption, which I think, again, I'll let the board do that if they want to, and even at the reduction to, as you say, to 16 students per session, that still comes to close to 800 trips through the neighborhood by students coming and going during a given week. Is that significant, or do you still contend that the word significant has to do only with a 1 hour timeframe?
That's the way the traffic engineering, the impact analysis works. We take the highest 1 hour combination of street and site traffic, because that's the worst case hour. And all of the analyses focus on the peak hour. In this case, that happens to be a little after or at the tail end of the evening rush hour, and this overlap hour that we've been talking about on between the classes. So the way the traffic impact is handled is 1 hour at a time.
You referenced the State Highway Access Management Code,
Yes.
and that's your source of the definition of the word significant.
Yes.
The actual definition, as it listed in their document, is 100 movements during the peak hour of the highway or development, and 10% of the previously anticipated daily movements. All right. Now, is that "and" in addition to or?
It's, for access permitting, it has to be both of them.
Okay. So now the question of the traffic impact study. The metering of traffic into Laurel Avenue from Sycamore is by Stop Street, right?
There's a stop sign on Sycamore,
Yes,
yeah.
a stop sign, which is the same metering device that exists on Church Street as it enters Laurel Avenue.
Laurel Avenue, yes.
All right. And when you counted the traffic coming off of Church into Laurel Avenue, you came up with a number of about 300 cars being able to exit, or I think it was a larger number than that.
No, we didn't actually count the movements into and out of Union.
Yes, you did. Yes, you did. It's on your, in your original document. You show the number of turns from Church Street, north and south on,
Oh, I'm sorry, Church,
on
I thought
Laurel.
we were talking about Union Street.
all right? Now, if you look at the timing of those turns, I'll use the word queuing because that was referenced before. There's significant queuing on Church Street. Now, you may never have been there or watched it, but I would submit that that's
Sure.
the case. It's a long queue during rush hour to get out there.
Yes,
And the reason for that is the amount of traffic and the fact that there's a stop sign there.
correct.
Now, we're talking about new traffic and a new stop sign and a new entrance from another road, Sycamore. Wouldn't you expect there to be a queuing situation there as well?
You're asking on the Sycamore
On
approach to
Sycamore.
Laurel?
Sycamore.
No, because the existing volumes coming out of Sycamore are very low. They're not anywhere close to the volumes coming out of Church Street. And again, that's to bypass the light. So we wouldn't be expecting a long queue to develop, not anything like what's happening.
The largest queue you can have is the 16 cars leaving. correct?
That's correct, right, if they
Yeah.
all left
Or,
at
and
once.
what you referred to as the pass-through.
Yes, if we had all 16 leave at one time and
Right.
none of them left the intersection, that would be
Right.
the maximum possible.
But would you expect there to be more than one car at that stop sign?
One or two At the most.
One or two you would expect.
Sure,
Okay.
at peak hours.
Okay. The idea that people are going to be coming off of Laurel into this facility, and because they're coming at different times, that's going to be a fairly easy thing to do. Have you done any time study of how long it takes a car to travel from the intersection, say, at Main Street to Sycamore
No,
during the rush hour?
no.
If that time period is a congested time period on Laurel Avenue, will that not slow down the capacity for people going to the studio from using Laurel Avenue to access it?
I
Or
said
if-
earlier.
more accurately, won't that stretch out the time more to get in and make that turn in there?
Again, the way we look at this is that 1 hour snapshot, and based upon the numbers that we ran for the yoga studio, in addition to the volumes on the street, we're not calculating or finding that type of problem.
To your knowledge, are there any sidewalks from Sycamore to the driveway to the yoga studio?
I don't think there are. I'm
There
not
are no
sure.
sidewalks. Therefore, anyone walking to the park or walking anywhere on Sycamore will be walking in the roadbed. Wouldn't you assume that to
If
be
there's no
logically the
sidewalk.
case?
Yeah.
So now, with the increased traffic, they'll be walking in an increased traffic volume.
And as I've said, there's no disputing, there would be an increase in traffic volume. So if there's a pedestrian, I would hope that the drivers would yield to the pedestrian.
I have no further questions. Thank you.
You're welcome.
Okay,
And
anyone else?
I want to thank both of the previous people who stood up and questioned, because you both only asked questions, and that was great.
Hi, Jim Diaforley, 32 Sycamore. I'm a little confused, it's probably me, don't take it personally. Okay, a lot of numbers, assumptions. Can you just explain to me how the traffic study is done? I mean, I know nothing about traffic studies, but I've seen those little cables on the road, counting cars, I'm assuming. Was there somebody out there actually counting?
Yes.
Okay, for what period of time?
From 5 to 8 p.m. And there was not a tube, we didn't put a tube down. We have boards that we use to count each movement, lefts, throughs, and rights on
Okay.
each intersection approach. So someone was physically there and counted each of those movements for those hours that I just said, 5 to 8.
On Laurel?
On Laurel, Church, and Sycamore.
On Sycamore?
Yeah,
Okay. 5 to 8, that was a time period.
from 5 to 8.
And for what period of time? How many days?
Oh,
Was it
one day.
1 day?
Mhm.
Okay, the 4th, I think, at some point.
Yes.
Okay. Do you see any impact with not only traffic, but potential parking on that stretch of Sycamore? A lot of comments made. Sycamore goes from 30 feet, where we live, with a sidewalk, down to, I believe, 17 or 18 feet in front of 29 Sycamore, or 26, and then 20 or 24 in front of 24. So I understand driveway, but people coming down, human behavior, do you see them parking on the street? And if they do, what impact do you think that might have?
I did mention that earlier. I don't see that, that a need for parking on the street. I think if you look at the plan that's up on the easel, the driveway is long. And now we've got 24 spaces plus the 4, plus the turnaround hatched area. So there's a lot of capacity on the site, in the parking lot and on the driveway.
So you think everyone, will go into the site, park there, won't park on the street?
I think it's going to be much more convenient to park on the property than on the street, yes.
Okay. The other question, you mentioned noticeable, negative. Explain the difference.
Well, we've talked about the volume of traffic using Sycamore
Right.
on this peak hour. It's low. There's not a lot of traffic there. So I think if you as a resident or someone who's familiar with that area sees vehicles exiting at the end of a yoga class, you're going to notice that, sure, because that driveway and that output wasn't there before. So that's certainly something that would be a noticeable impact. But in traffic, engineering, the measurable impact is this level of service scale. And there is no negative impact because we've combined the projected volumes with the existing volumes, we've done the calculations. It's not a negative result. So while there may be a visible and noticeable increase in activity at this location, it's not a negative traffic impact.
So is it fair to say one is objective, one is subjective?
Well, certainly, I'm not going to dispute that there's going to be an increase in traffic, but from my traffic engineering perspective, it's not a negative traffic impact.
Right. Have you been to the site yourself?
I have, yeah.
Yeah. Very good.
Okay.
Thank you.
You're welcome.
Okay. We'll close the public and move on to another witness.
Before we go on, can I ask our attorney a question?
Yes, sir.
We sit here after having lived in the town for a while and also visited the site. We've listened to a lot of testimony about traffic, and can we also rely upon what we've seen with our own eyes as coming to these opinions?
Yes, yes, you may.
Okay.
Okay.
Just a little bit. Leave your report just in case.
We're done.
Okay. I just need to recall very quickly, Mr. Ardman, just to clarify the widths of the road on Sycamore, where they are, just so that the board has no misunderstandings of where the road is at a certain distance as in and around the subject property.
Okay, I'll just remind you, you're still under oath.
Thank you. So there were some questions from the board, and Mr. Healy brought up about the widths of the road, and I think actually was going to say something. The last neighbor also touched on it and actually was quite accurate in the explanation. So if you're looking at the board there that we have up, that exhibit that's on the board now, this is our alternate parking plan. You see our proposed driveway here, basically towards the, say, the right side of our property line. To the right of that is to the east. To the east of it is really where the most necking or narrow part is. That's where that 17 feet is that Mr. Healy was correct in saying, and I was on the record previously as testifying to as well. So basically, there's kind of a funny jog in Sycamore where it's wider and then it swoops in, as was stated, just in front of the one property to our east. And then as you go further east, to the houses down Sycamore, it becomes like a classic wide subdivision road where the roadway is 30 feet at that location. There is sidewalk. So east of us is the most narrow across basically just before the driveway, the adjoining lot, then it widens out. So once you get from our property west going back towards Laurel, the property, you know, the pavement just basically in front of us is basically 24 feet, and then it does neck at our neighbors again down to about 20 feet. So just for the record, just west of us is 20, and then when you get to the intersection of Laurel, it's maybe just slightly wider at about 21 feet. As part of the engineering comments in our agreement, just to the east of us, to take that kind of swoop in the pavement out and to straighten it out a little bit, we had agreed to widen that transition out so we can, you know, get that a little bit wider as you cut through. But just wanted to clarify for the board, so the neck down is not between us and Sycamore. It's actually after us as you're heading east into Sycamore. Not from us to Laurel. That's all I wanted to add.
What was the comment from the engineer?
That basically on the right side or the east side of the driveway, to taper our driveway out so that it kind of widens the roadway and tapers that back into Sycamore.
Okay, and is that's in front of your client's property, or does it extend beyond?
In front of our client, and if it's in the right-of-way for a certain extent more, you know, it could go another 20 feet or so. It would not go the full frontage of the neighboring property, though.
Okay, but the portion that's less than 20 feet, how long of a distance is that?
that's less than 20, it's probably about, because their driveway kind of wide, it's probably about 50 or 60 feet, if that.
Okay, so
And-
for
and
about 50 or 60 feet, it's
And
less than,
we're going to widen out 30 to 45 feet, depending where we all agree that widening goes. If we had to take it a little further, we could.
all right, thank you.
I have a question that's unrelated to this. Do we have any, I know we have tall light poles in the back around the parking lot, right?
Yeah,
Do we have any in front of the yoga studio on that driveway?
yes, there's one on the entrance.
Why is that there? Is that because there's no pedestrians there?
Right.
Last time I checked, all the cars have headlights even when it's dark.
That's
Does that
correct.
need to be there?
If we're in agreement with the board that you can direct, the engineering staff, that can be reduced,
Like
eliminated.
patio lights or something, you know?
Yeah, something.
The typical engineering comment is they want the light pole that high. The board can say, we don't need one at all, or we can make it lower. But they want us to demonstrate that we can put 1.0 foot candles?
.5 foot
Point-
candle
0.5
everywhere. We've already reduced it, but if the board is okay to reduce it further, we can do that.
Yeah, okay, good. I'm glad you came back.
Okay, next witness.
Before I call my planner, I'd like to ask Mr. Dominic a couple questions, if I may.
I have to wake up, you
Remind him
mean?
that he's under oath.
Is he under oath?
Yeah, Pat swore me in.
Mr. Dominic, you're the zoning officer of Franklin Township, is that correct?
Yes.
And you're familiar with the zoning ordinance of the township?
I hope so.
We hope so. And you heard the testimony of Mr. Ardman in a previous hearing talking about, a potential residential subdivision of 5 or 6 houses, correct?
I did.
And it's an R20 zone, and, when you engineer it, it may be 5 or it may be 6, but this property is eminently subdividable into a residential subdivision.
Yes, it is.
Okay, and in doing a residential subdivision, you would have to then build a road to service the property, is that correct?
Absolutely, or the board would not approve it.
Okay, and when you build a road, it has to meet municipal standards
And the RISA standards, yes.
Yes, and it also would require lighting along that roadway.
We would require lighting, yes.
And that lighting would have to meet RSIS and municipal standards.
Yes.
Correct? Now, let's say the applicant decides not to subdivide the property and the board were to deny an application. This property can be developed for a large single-family residential dwelling, is that correct?
Yes.
Okay, and
With a building permit only.
with a building permit only. And the percentage of lot coverage in the R20 zone is 15%.
I believe that's true. yes.
Okay, and 15% of the subject property would result in a house that you can build or outbuildings of about 25,000 square feet?
Yeah, if someone was crazy enough to build something at 25,000 square feet, but yes, in theory, yes.
Okay, and you can have, you also are allowed to have impervious coverage.
Absolutely.
Okay, and do you know off the top of your head what the impervious coverage is in the residential zone?
Is it 30%?
Try
25?
25.
25, 30, yeah.
Okay, which is basically about an acre of the lot could be impervious.
Correct.
Okay, and are there any, if you were to build a single-family house, are there any restrictions other than setback requirements?
Well, besides the impervious and the lot coverage, no.
All right. So with this application, we are proposing fencing and buffering and things of this nature. If we were to build a single-family house, would we have to buffer it from our adjoining property owners?
No, there's
Okay.
no requirement for that, unfortunately.
Okay. And if there is lighting that the owner of the property wants to put around the subject property, are there any requirements as far as lighting?
No.
And there are no measurements that need to be taken, light can spill over on adjoining properties, you have no regulations concerning that?
We have no regulations, that is true, unless there's an attractive nuisance.
Okay. And obviously, if somebody were to build a single-family house or even with a 5-lot subdivision, you are allowed to have pools, basketball courts, whatever a single-family residential dwelling would permit.
Absolutely.
Okay. Are there any restrictions as to how late somebody can use their pool or how late somebody
No,
can?
unless there's an attractive nuisance or they're violating the noise ordinance, absolutely not.
Okay. So basically, if this was developed residentially, the site would operate as residential development with no controls as far as lighting, noise, or things of that nature, other than,
Other than your normal
Noise.
health department or attractive nuisance ordinances, yes.
now, the other question, if Nagiza was denied this application and decided because the yoga studio doesn't work where it is, that she's going to close her yoga studio, and she decides that every night at 5:30, she wants to invite 10 or 12 of her friends to come to the subject property to do yoga on her 5 or 10,000 square foot house. Doesn't charge any admission, she's not a corporation, she invites people to the house. Can she do that?
She can, because the case law allows for that type of use. Just like if a person owns a residence and wants to have a prayer group or wants to have a Boy Scout or Girl Scout outing, they are allowed to do that.
Okay, and if Nagiza's husband happens to collect Harleys and decides that every Saturday and some weekday nights he wants his friends over with their Harleys to tinker on their cars, I assume that can be done.
As long as they don't violate the noise ordinance or create an attractive nuisance, yes.
Okay, and instead of having Harleys, let's say he was a car collector. Can he keep on the property 20 cars, 25 cars, 30 cars, assuming they are legally registered?
As long as they are registered and insured, yes.
So there are no restrictions to the number of vehicles that could be on the property?
As long as they are registered and inspected and insured and they're on an impervious surface that meets the requirements or ordinance, that is true.
Okay. Now, I assume in your capacity as zoning officer, every once in a while you get people to come to the municipal building to register some complaints.
Once in a while, yes.
Yeah, okay. And when you get these complaints, in your experience, or most of the complaints that you get about the business community in the municipality violating the township regulations, or questions or complaints about neighbor upon neighbor complaints?
95% of them are residential, because when we do site plan applications, the board typically puts restrictions on them, and they have to comply with them. Unfortunately or fortunately, there are very few regulations regarding residential, so the majority of the complaints, 95% of them are residential in nature.
Thank you very much, Mr. Dominic.
Since that's technically a witness, then technically we should open to the public.
Yep.
And if the public has any questions for the on the testimony Mr. Dominic offered, now is your opportunity.
So, Mr. Dominic, if this were to happen...
Would you-
Oh, I'm sorry. I'm Kathy Pavlak. I live at 35 Laurel Avenue, right on the corner of Sycamore and Laurel Avenue. If this were to happen, if there were to be built on this property a gigantic McMansion with a gigantic pool and 100 Harleys, would it still, who would live there, in theory?
I can't answer that because I have no
A
idea.
family?
I don't know.
Okay. Could we assume, since it's a residence, and not a business location, that private citizens family.
I
What?
can't, I can't answer that. I
Okay,
have
you
no
can't answer
idea.
whether a
Anyone could
family
live
would.
there. I can't answer anyone could live there.
Okay. But, and we can't assume that if it's a residence that's built, there will be a family living there, as opposed to a
There
business.
could be no one living there, there could be 50 people living there.
Okay.
I can't tell you
Okay.
that.
Okay, okay.
But just to clarify, but what she's asking is, if a house was built there, it would be for people to live there as opposed to a business.
Yes.
Yes, thank you. You're right. Thank you. That's all. Thank you.
Anybody else?
Hi, my name is Rod DeLeo. I live at 28 Sycamore. And my question is it safe to assume that the reason why 95% of the complaints come from homes is it's because we're not heavily regulated by you guys as businesses? For example, I just moved to my house. Nobody told me I can't blast the music. I can't
Absolutely, because
have, light or-
most single-family homes, they get subdivisions, and most businesses come here and get specific regulations imposed upon them, so that is true.
It is true. Okay, and my last question is for the lawyer. I guess he, likes to speak hypothetically. So hypothetically, I could say that the traffic test could be wrong because, it's just on paper, just like, when you take a physics class, the solution to the
Okay, we
test
can
always works.
appreciate your comment, but try and save that for later
This is a
questions
question
for
time.
them.
Yeah, okay. Well, my question was for him, is it hypothetical that he's talking, or is he trying to scare everybody into saying, oh, we can just forget about this and have somebody make a lot of noise? I mean, is that a fair question?
I think it's probably best, there is going to be a point, hopefully later tonight, where you can make a statement. I think your point's probably better made as a statement.
I was trying to word it as a question, so, I mean.
I think it's probably better for you to make that point later as a
Okay,
statement.
I will.
Hi, Serene Hashim, 47 Laurel Avenue. Actually, my question into the zoning. Few years ago, actually 4 years ago, I came to the township with an architect and a partner and a real estate to buy 43 Laurel Avenue. And I came with a question, I want to turn it to bed and breakfast because it's 3-bedroom and 3-bathroom. And in the same minute, I was turned away because it's residential area. So why bed and breakfast? For maximum 6 people will be there. In Laurel Avenue was turned away, and a yoga center was not.
You have to, what do you mean by turned away? Who'd you speak to?
In the zoning, I came here with an architect, a partner, Dr. Taha was my partner, and a real estate. And the first thing says, then go further with the
No,
plan.
I'm asking, who did you speak to? Did you speak to myself or Mark? Because the two people
I'm
in
sorry,
planning
I
and
didn't-
zoning that you would speak to, and correct me.
I think I remember a young, handsome man. I think it's you.
As opposed to me? Motion to adjourn.
You just got dished, Mark.
Totally. I did not come here for that. I think that to clarify perhaps the point that was being made, though, is, did you come to the counter?
Yes.
Okay.
Here, I met 3 people. Actually.
Yeah, and
So I think what,
Everybody says, don't waste your time. And actually, he suggested I go buy the house in Raymond Road and the corner of 27 and Raymond Road. And it was for sale, which is now it's on scene. And he told me it's a better situation because 27 is a business district. And I really went to the house, but it cost more than $1 million. And it was run down that time. And now on scene, which is a center for is buying it. And this is what was the suggestion. I should not consider Laurel Avenue is a residential area. And I said it's just 3-bedroom and 3-bath. And I'm a teacher and I just want to run it from home. And the idea was, don't bother, don't waste your time in architect and money. Take the one in Raymond Road and 27.
okay, and I, since it wasn't me, and I'm sure Vince,
we've already determined that, Mark.
I'm sure Vince doesn't. My wife will disagree, by the way, vehemently. But I think just for the record, to be fair, in terms of apples to apples, frankly, I think when the yoga studio came, they probably came to the counter. And they were probably told the same thing that you would have been told, which is, as far as the counter and as far as Vince being able to approve it, they got turned away as well, because it's not a permitted use. That's why they're here. That's why they have 4 hearings to convince this board that despite getting turned away at the counter because it's a residential zone, they should be allowed to do it. So as far as, your treatment at the counter and what you were told in terms of the zone, you were told the same exact thing. They just decided to go the use variance route.
I don't know, that's my own feeling, but I feel like the zoning has been advising them in other matters, or helping them in this case.
Okay.
I like her anyway.
Wow, hard act to follow. Jim Dyer, 432 Sycamore. I'll hold my comments to the end. This keeps coming up every meeting, which is quite frustrating, about this, leverage and almost scare tactic about the houses. But I do have a couple questions for you. If it turns into a housing development, whether it be 4 or 5 houses, you would require a road same width that Sycamore is now, 30 feet?
Well, we would require a road to meet the RISA standards depending on how much parking they were going to have on 1 or 2 sides, and that would be discussed at the planning board level.
No variance would be required, as long as it's developed within the R2 zone.
I can't tell you whether it'd be a variance, because we haven't had that application. They may ask for a variance or they may not, but we would hope they wouldn't.
Right, okay. So it would be primarily or a residential development, whether it be 4 or 5 or 6 homes.
They have indicated that if they don't get approval, they may wish to sell it to someone who may make an application for a residential development.
Okay, in a residential area.
It's zone residential, yes.
Okay, thank you.
Anyone else? Okay, we'll close that part of the meeting. Next witness.
Mr. O'Brien,
This would be the final, right?
this is the last one. Can I excuse Ms. Dolan? I assume everybody's finished questioning her and she has another commitment. Can she be excused?
Get back in traffic? Yeah, go ahead.
Solemnly swear or affirm to tell the whole truth, nothing but the truth?
I do.
And your name for the record?
My name is Kevin O'Brien, O-B-R-I-E-N.
Mr. O'Brien, what is your occupation?
I am a professional planner licensed by the state of New Jersey.
Okay, can you give the board the benefit of your educational and professional background?
Pass that up and accept his credentials. unless you
Mr.
have-
Chairman, with all due respect, I'd like to at least get something on the record in the event that this thing goes beyond
Go
this
ahead.
level, so I think I need to at least,
We have seen and heard his testimony.
I will not ask him to
Go
go
ahead.
through all his credentials, but at least some of his
Don't
credentials.
start with high school.
He didn't go to high school.
Graduated yoga school. A graduate degree from the New Jersey Institute of Technology. I've been a licensed professional planner for over 20 years, been in the planning industry for over 30 years. I teach planning and zoning as an adjunct professor at Rutgers University, as well as for the Association of Planning and Zoning Administrators and New Jersey Planning Officials. I've been published, and I serve about a dozen municipalities, work currently in about 5, and I've appeared before over 200 municipalities in the state, as well as a number of superior courts and the New Jersey State Legislature.
Well,
That's enough.
You did that because I never heard the Rutgers part before, so that was, that's something extra.
Thank you, Chairman.
Okay. Mr. O'Brien, you were retained by the applicant to do a planning analysis, and you're familiar with this application. You've reviewed all of the plans that have been submitted, the amendments to the plans, all the reports and the studies. Is that correct?
Yes, it is.
And are you also familiar with the zoning ordinance of the Township of Franklin, the master plan of the Township of Franklin, and the municipal land use law?
Yes, I am.
Okay. Have you also visited the subject property?
Yes, I have.
And also the areas surrounding the subject property?
Yes.
Okay. Can you indicate to the board why we're here tonight?
The applicant is applying for a D1 use variance, that's for a nonconforming use, to convert an existing abandoned residential structure into a yoga studio. The application has been changed in response to comments made by the board and the public at past hearings. For instance, the sign has been removed. A sign variance is no longer required. The parking layout has been changed. It now provides a single line of parked cars facing east, away from the adjacent residences and allowing a 27-foot wide buffer on the west side of the parking lot. This gives a much more residential look to the driveway and to the parking, as you can see on Mr. Ardman's exhibit.
Are there, in your opinion, any unique aspects to this application?
Yoga is an ancient practice that emphasizes tranquility and serenity to quiet the mind and strengthen the body. The adaptive reuse of the existing cottage as a yoga studio on a 3.78-acre lot will ensure tranquility and serenity for the yoga students. The current studio location on Route 27 in Kingston no longer promotes that tranquility and serenity. The restaurant next door is very busy during evening peak hours. The Friendly Rentals Center, also next door, consolidated 2 locations into the location next door, adding a contractor equipment capacity to the party rentals, creating a more noisy environment during the day. The property behind the subject property to the north is the quarry property. There's no residential activity on that. The property across the street from this property is the former school, which is now currently owned by the municipality and will be put to some type of municipal use in the future. So there are no residences on that side either. The existing abandoned home will be rebuilt into a yoga studio while retaining its current residential appearance. The building will continue to look like a cottage and will have no commercial aspects visible from the outside. It is a unique building, as you've seen it, that unfortunately has been neglected. This application will save that building. The studio holds 4 90-minute classes per day and have a 30-minute break between the classes. This gives participants plenty of time to leave and allows the next class to gather without worrying about accommodating parking for both classes simultaneously. Many participants, as you've heard in previous testimony, are couples, friends, or relatives, some of whom travel together.
Wait, we have to stop, because you've just said something that I think is incorrect.
Okay?
On the weekday, there's only 2 classes.
No. Weekday, there are 4 classes. And the times are 9:30 to 11, 12 to 1:15, 5:15 to 7, and currently 7:15 to 8:45. That's Monday through Thursday. On Saturday and Sunday, there are 2 classes on Saturday and 1 class on Sunday.
Okay, my mistake.
We can provide a copy of that if you want.
No, that's okay.
Okay.
The yoga studio is an educational facility that promotes the public good by providing classes to the public. While class sizes are in the 10 to 15 person range, as you've heard in previous testimony, the new facility has agreed to accommodate no more than 16 people during the week and 28 people on weekends. No other activities, such as parties or rentals, will occur in the studio. The current plan moves parking away from Laurel Avenue or the western side of the property and installs a 27-foot wide buffer to Laurel Avenue. All of the cars will park on the eastern side of the driveway, so any headlights will face away from Laurel. The proposed driveway will have a residential-looking opening on a winding drive and give a residential rather than a commercial appearance. The proposed studio will adaptively reuse the existing dilapidated building, which promotes the purposes of zoning. The house has been empty for approximately 15 years and is an eyesore of the neighborhood. In terms of the master plan has a number of goals. Among them are provide adequate community services and facilities to serve the needs of all current and future residents in the township. And it goes on to state, continue to provide adequate services to fit the needs of the township and continue to evaluate the adequacy of existing facilities. And this application supports that goal by providing for the relocation of a low-impact yoga studio from a very busy commercial strip mall to a more suitable, quiet residential zone.
Does the application, or is the application supported in any way by the purposes of the municipal land use law?
The municipal land use law does have several passages that apply to this application. The first is A, to encourage municipal action to guide the appropriate use or development of all lands in the state in a manner which will promote the public health, safety, morals, and general welfare. Certainly, the public health is promoted from a yoga studio. Item G, to provide sufficient space in appropriate locations for a variety of uses in order to meet the needs of all New Jersey citizens, and that would include the people attending the yoga studio. And item I, to promote a desirable visual environment through creative development techniques and good civic design and arrangement, and that is provided by the adaptive reuse of this facility. And I believe the application is consistent with all those passages by adaptively reusing that eyesore that has not been lived in for 15 years, providing a low-impact yoga studio that promotes the public good in a location that is suited for it and is 3.78 acres in size. Also preserving 58% of those 3.78 acres, or 2.2 acres, as has been proposed. Preserving it as open space is also a public good that serves the entire community by reducing building and impervious cover, lessens municipal costs, and maintains the scenic views in the neighborhood.
Will the granting of this variance, in your opinion, have a negative impact?
Although this is not in the historic district, the Historic Preservation Commission suggested making the parking lot and driveway more residential looking, which has been done in the most recent plan that you have in front of you. This project will maintain the current residential look of the property and the neighborhood, which benefits the neighborhood. The Historic Commission was asked to review the plan, not because it is historic or it's in a historic district, but because the rules say that any property within 1,000 feet of the canal requires the Commission's review. It is not in the village of Kingston. In fact, it's over 1,400 feet from the village and is not a historic house or in a historic district. But nonetheless, the applicant has agreed to meet the suggestions of the Historic Preservation Commission by making it look more residential than originally proposed. The applicant does have an alternative plan that is completely conforming to the R20 zone. 5 or 6 single-family homes can be built on the 3.78-acre property. They would be accessed by a cul-de-sac, which would run north from Sycamore and then turn east behind the existing homes on Sycamore. That would make the 4 residential lots on the north side of Sycamore through lots and would make lot 140.01, the one immediately to the east, would give that lot 3 front yards. There will be significant costs to the township for items such as street maintenance and school students, if there were 5 or 6 homes on this property. Compared to the alternate possibility of 5 or 6 conforming one-family homes, the proposed yoga studio will have less of a visual impact upon the area and will preserve 58% of the 3.78-acre lot. This is a significant amount which will enhance neighborhood aesthetics and property values, as opposed to possibly a 25% maximum impervious coverage, which would amount to 0.95 acres, almost 1 acre of maximum impervious coverage that is allowed in the R20 zone. The traffic report has concluded that there will be no negative capacity impact upon the adjacent roadway. The expected traffic generated by 5 or 6 single-family homes is about the same as that projected by the yoga studio, resulting in minimal impact to the neighborhood.
Really?
I don't think
Yes.
that's true. Why are we having
A single-family home generates somewhere in the neighborhood of 10.1 trips per day. So, if you were to have, say, 6 homes, that would be 60 trips per day. If you had 6 homes that had, say, 4 cars parked out in front of each one of them, that would be 24 cars, which would be the equivalent of what is being proposed in the parking lot here. And those 24 cars would be able to access those 5 or 6 homes whenever they like, not at staged times at the 3 or 4 classes on a daily basis or 2 classes on a Saturday or 1 on a Sunday.
And just to clarify, so there's no misunderstanding, when Ms. Dolan testified as to the trip generation for the peak hour of the yoga studio, it was for vehicles that were coming in and coming out to the yoga studio during that 1-hour period, which were the 32 vehicles, correct?
That is correct.
Okay, and then The residential component, as she testified, would be 4 vehicles during that time.
Correct.
Okay. But in your analysis, you're looking at the trips that are generated basically during the course of a day from a single-family residence, and with people leaving for work in the morning, people going out in the middle of the day and doing things of that nature. So those are the number of trips that you're looking at that are being generated.
Sure, and that average number is 10 trips per day per house.
Okay, now, when he says that average number is 10 trips per day, is he testifying from a traffic engineering point of view or as a planner?
I'm testifying as a planner who's also a member of the Institute of Transportation Engineers and has a transportation component to my graduate degree.
But to arrive at that figure of 10, did you do,
That is a statewide number that is in the RSIS.
okay, as long as it's explained how you,
Yeah, that's not our number, that is a statewide number. RSIS predicts 10.1 cars per day in a typical single-family house. It is arranged depending upon apartments, rentals, townhomes, and single-family homes.
okay, I just want everyone. to
So
understand
then,
you're not-
if we had 6 homes in that area, there would be 60 trips in the day.
That is correct.
And if there's 4 classes being given every day, how many trips is that? 120, yes?
At a maximum of 16 over the 4 trips, over the 4 classes per day.
But they're going both ways, they're coming in, they're going out.
Right.
Right?
Just like you do in a house.
32 times 4
Right.
is,
128.
all right. And you know what? What's interesting is that the traffic engineer testified to the idea that if there were less than 100 trips, of course, that was within a 1-hour period. If there's more than 100 trips within an hour, that was significant. But if there was 100, more than 100 over the daily period, that really didn't impact. So that it sounds like there's twice as many trips per day being generated by the yoga studio as by the 6 houses.
It sounds like that, and certainly those are the numbers. One can't argue with those. What I would state is that those trips are done at predictable times in conjunction with the classes that are being offered, and they are controlled by should this board give an approval, it would be controlled by that approval. The trips that come in and out of a house will be all day, throughout the day, without any prediction.
And the night, yes.
Well, yeah, but the flip side of that.
You're talking
is that
about-
The 60 trips are spread out during the day.
That is
As
correct.
opposed to 28 vehicles within a confined period of time, the other 28 in a very confined, that was the whole issue, the whole series of questions from the last, and concerns
Well-
from the last meeting was not necessarily, not just the volume, but the fact of the concentrated time period. That would not happen with single-family homes. It would be spread out over the day.
Well, and the other issue is too, is that 128 or whatever number is the absolute worst-case scenario based on everyone driving themselves, which the applicant has testified is about half of that. So that's the worst-case possible scenario that on the basis of the testimony isn't what's going to happen. So just,
And
You're
because of
talking
that,
about-
Mr. Dominic, my testimony was that I felt that this was equivalent, and at 60 trips for 5 or 6 houses, that what was testified to is to the people who actually go there.
and that was my point. It was based on her testimony, not on what we consider the worst-case scenario.
And at a worst-case scenario, at 128, that would be over 4 time periods a day with a half-hour separation between each of the classes.
You're talking about rush hour only?
No, that's,
Are you talking about all day, or what are you?
there are 4 classes through the day. The first one's at 9:30 in the morning, after rush hour. And then the next one is at noontime, and then the one after that is at 5:15 in the afternoon.
Yep, I had a question. Are we at questions?
Perhaps, Mr.
Question.
Chairman,
I don't
think
if we
it's-
could let him finish his testimony,
Okay.
I
that,
think we need to finish, yes.
Yeah.
Then we'll save the questions.
okay.
You've heard already testimony that a very large house could be put on to this property at 15% of building area, a 24,829 square foot footprint could be erected here. which would be equivalent to 6 4,000 square foot homes. At 25% maximum impervious coverage, that would be 41,382 square feet of coverage. But the proposal in front of you is for the rebuilt cottage with proposed visual screening, landscaping, and building improvements, which I believe will provide a positive impact upon the area. And in terms of negative impact, I see minimal negative impact upon the neighborhood from allowing the yoga studio and residents, and a large positive impact by preserving 2.2 acres of prime residential land as open space. The current applicant would have far less of an impact upon the neighborhood than the construction of 5 or 6 conforming single-family homes. This enhances property values and the neighborhood as a whole. By approving this proposal and this use, this board regulates the activities on this lot and limits them to the yoga classes at set times with set amounts of people and with maximum numbers of vehicles. Not only that, but the owner is going to be living on the premises. There'll be a residence in the back here. So in one sense, there will be somebody who cares about what happens here on the property. And in that way, I believe there will be a degree of self-policing that I think will certainly address any problems with overparking and any problems that may arise with the consideration of parking problems.
Mr. Lanford, you just testified to the fact that we're going to have 2+ acres preserved. Does that mean that you would accept a conservation easement on those 2.2 acres so that, in essence, we would be assured that those acreage would be preserved and would never be built upon?
I think the way it should be handled is as long as the non-conforming use is there, it would be preserved in perpetuity. If for some reason the yoga studio disappears, I mean, I could talk to my client about that a little bit further.
I would think you want to talk to your client about that because that's,
Okay.
he just testified that it's going to be preserved.
We'll preserve.
And if it's preserved,
It
means
will be preserved.
there's going to be okay, that's relatively important.
It will be preserved.
So that means that
She moves out.
for
Nothing can be built on
the
it.
life of the world,
Based on.
Nothing can be
you
built
can
on
never
it.
build anything else.
Now you've
That
put
is
it-
true.
For the life of the world, she's agreed to a restriction on that 2.2 acres.
We would accept the conservation easement, which means nothing could be built upon it. That was why it's relatively important for your consideration.
That's a done deal?
I just put it on the record.
Condition?
Yeah.
Assuming you approve it,
Well, I think
well
it's-
then, yes, then I think
it's
he's,
important because if she would move out, then we've got a building established for a commercial use and have
No.
lost
No,
the
no,
conservation
no,
easement.
no.
no, they,
It's only a yoga
As long
studio.
as it stays,
It stays,
assuming you approve it, before they got any sign-off, they would have to file the necessary conservation easement that would render that property having no ability to be built upon in our standard language, and they would file that with the deed, and it would be till the end of time.
finish the testimony.
Okay.
Because we're getting a little disjointed.
And as has been pointed out, a conforming 5 or 6 house subdivision would have no controls on them, unlike this present application in front of you.
Mr. O'Brien, the other thing that I think we haven't touched upon, this property is in an R20 zone, and while residential uses are permitted in the R20 zone, there are certain conditional uses that are permitted within the R20 zone also, are there not?
Yes, there are.
And what conditional uses are permitted in the R20 zone?
Membership swimming pools, public utility installations, schools, community residences, churches, and other similar places of worship, wireless communications antennas, professional offices in the R20H.
But that's.
Well, we're not-
permitted
That's
here.
not us.
That's
Okay.
not, so,
Sorry about, strike that.
so there are other non-residential uses that are permitted, conditional uses in the zone, is that correct?
Such as churches and schools and community residences, yes.
Thank you. Have you reached a conclusion regarding this application?
Yes.
Okay, and in order to do that, what things do you look at? What are the legal requirements that you have to look at for the grant of a variance?
A use variance for a D1 nonconforming use has to pass a three-step test for this board to be able to approve it. First, the applicant has to show special reasons that are rooted in the basis of zoning. Second, the applicant has to prove the first part of the negative criteria, which is that the application can be reconciled with the master plan and zoning ordinance and show that this use is particularly suited for this location. And then last, the applicant must show the second prong of the negative criteria, that there is no negative impact on the neighborhood or on surrounding properties. And in my opinion, this application does meet those tests. Special reasons have been demonstrated because the application is for a use that conforms to the goals of the municipal land use law, specifically goals A, G, and I, by promoting the public good, serving the public health, and providing a desirable visual environment. This application can be reconciled with the master plan by proposing an adult educational facility that emphasizes tranquility and serenity that does not adversely affect nearby residences and has a positive effect upon the neighborhood with a much less impact than conforming subdivision of 5 or 6 single-family homes. This application will preserve 58% of this lot, 2.2 acres. A vast portion of this lot is open space, enhancing both neighborhood aesthetics and property values. The site is particularly suited for this use. It is a quiet place that allows reflection in a semi-rural area with the open quarry land in the back and the public space of the school and municipal facility in the front. This is a better planning alternative to the allowed single-family homes or one very large home. Lastly, the application has met the negative criteria and has shown that there are no negative impacts and that the benefits of granting this application outweigh the detriments. And I would conclude that I believe this application can be granted without substantial detriment to the public good and without substantial impairment to the zone plan and zoning ordinance.
Thank you, Mr. O'Brien. I have no further questions.
Okay.
Board questions?
Yep, I have one. In listening to all the points you've made, how it's good, how the health of the people that use it are impacted, adaptive use is a positive. When you got to the negative, you didn't really say there were any negatives. You basically said, you made the point that we've got a breakdown, something about our zoning doesn't work. That is to say, it would be a better use to do this than to build out according to our zoning. So you're saying that our zoning is unworkable?
I would not say that, and I would disagree with that way of putting it. What I would say is that I believe that given the two alternatives for this property, and each application is judged by its unique, specific applications. In this particular case, having 5 or 6 homes going across that open space from left to right, and a cul-de-sac that comes in off of Sycamore, goes north, turns east, making a corner property with 3 front yards next door, and the other 3 properties through lots. I don't think that's a desirable planning alternative for the neighborhood. Instead, leaving it just as it is outlined there with the existing home, repurposing that home, putting a residence behind it, and using it for a low-impact yoga studio that meets 4 times during the day and on a weekday, and what was it, 2 on Saturday and once on Sunday?
3 on Sunday.
3 on Sunday, thank you.
If we were,
Given
go
the
ahead.
2 of those, I think that this is a better planning alternative than putting those homes back there and developing all that property, because you're going to lose that open space, which the neighbors are currently using. You're going to lose the scenic views out towards the water. You're going to lose the benefits of having open space, which currently the neighbors enjoy both in terms of use and in terms of property values. Property values are higher when there's open space next to it.
Got it.
Any other-
Quick clarification, because I heard some rumbling from the public when you said that the residents are using that open space. What do you mean by that?
We have a parking lot.
I don't think you meant what might have been implied. If you could just explain what you meant by that term.
The fact that that space is vacant and open allows people to use it for vistas, for views, not that they're using it physically, but it's part of the fabric of the neighborhood, and that use is part of the neighborhood.
All right, thank you.
From our point of view, if it were a school or a church or some of those that you listed, beneficial uses, inherently beneficial uses, we would have, there would be a different criteria in looking at it.
That is correct.
Yeah. And so.
And a different impact as
Yeah,
well.
and so what we're looking at is a business. And in a business, it could be a retro fitness or, it could be something, but what I'm basically saying is the negative impact on the zone plan is from what I'm hearing, what you're saying is that the zone plan itself doesn't work. It's not as good as what you're proposing as a what'd you call it?
An adaptive reuse.
Adaptive reuse. Even though what's being put there can't be included or considered in beneficial use or inherently beneficial use.
It is not inherently beneficial, although it is one that.
But you did say a lot about yoga.
It's a yoga studio.
Yeah, and it has health benefits, you made that point.
Because it's a yoga studio and not a retro fitness, those are two completely different physical related
Yeah,
facilities.
what's the difference? I mean, one is muscles and body, and the other is,
I think that a retro fitness is one that
Gets a lot of people.
generates a large amount of people because of the need to fill that facility with as many people as they possibly can in order to make that profitable. You've heard the owner of this facility testify that they only want to have so many people because that's what yoga is. It's supposed to be peaceful and serene. It's not supposed to be 50 people pumping iron in a facility that's many, many times the size of this. So different experience completely.
okay, so in the final conclusion, you basically said that if you develop it as the adaptive use, it's going to be better than your zone plan.
Not that it's better than the zone plan, because the zone plan is adopted by the town. It works in the town. It is something that delineates zones, makes the town a better place, and zoning works throughout the town. There's a zoning board, and there are use variances allowed for unique and special circumstances when an applicant can show the board that an alternative in front of them is better than what you could do otherwise on a piece of property. In this case, there are a number of advantages to allowing the yoga studio here instead of doing 5 or 6 family home subdivision. Putting in 5 or 6 families across from Sycamore, north and then east, means that you're making 3 or 4 properties through lots. One of them is going to have 3 front yards, and there's going to be homes here instead of 2.2 acres of open space that the applicant has indicated would be preserved permanently. That's something that benefits everybody. And not that there's anything wrong with the zone plan or something inherently wrong with it. It's just that in this particular case and for these particular reasons, this is a better planning alternative than to what could go there.
Let's see, there's another point I was going to make.
Let me just
Go ahead,
take one,
jump
okay?
on, yeah.
Mr. O'Brien, you keep talking about the benefit that this open space is going to have to the residents of this area. Now, this is where the open space
Hey,
is.
Bob, could you do me a favor? Could you take the mic, because it won't pick up as well on the, thank you.
Hello. Okay, good. Now, this is the open space here, right?
Yes.
Okay? Now, I can see, you would agree that these are the houses that would benefit from that. How do these houses here with the buffer and the parking lot, how are they going to benefit from the open space?
They're going to benefit from the application as it currently is by having not only the green buffer, but 27 feet between the parking lot and their property lines.
I think actually what that's going to do is that may minimize the downside of people parking here and talking in the parking lot and moving cars and going in and out. I think it's going to reduce the negative, but you cannot tell me that that is somehow a positive related to that open space, can you?
For the homes on the left, no, not necessarily.
Okay, thank you.
On the other hand,
Don't steal the mic.
on the other hand, having open space in the neighborhood.
The public's going to speak in a little bit, Bob, for probably quite a while.
But I would also point out that those other properties that you pointed to on Laurel are going to benefit from that open space being in the neighborhood, because having open space in the neighborhood is a positive for everyone as a whole.
I just wanted to make the point that we're kind of in a box here. We got a zone plan, and we have a proposal that's outside the zone plan. And when you don't, he makes a good point about negatives. And what we really are looking for is no negatives. You want a breakthrough, not a breakdown in the zoning and a breakthrough in what you get at the end.
Cheryl?
Could you go over the surrounding land uses again? Did you say something about a restaurant?
No.
Okay, you said the word restaurant. What were you talking about?
That was the previous location.
Okay, so you were talking about the previous location.
Route 27 is a shopping center.
Okay,
There's a restaurant
so the surrounding,
and a rental place on the other. The restaurant's busy in the evening, and the rental center is now very busy during the day because they relocated a contractor facility.
okay, so the surrounding land uses here are what?
Residential on the west and the east, the quarry to the north, and the school to the south.
Okay, what's directly across the street?
That's the school, public land, which is owned by the township.
Okay, isn't there a house right across the street?
No, not right across the street from this property.
Okay,
There
but
is one
on,
on the corner.
all right, that's across the street.
And technically, the property across the street, it's a former school, it's township open space.
Okay.
Oh, go.
Yeah, I have a couple more. You said property values are higher next to open space. You're not testifying as an appraiser, are you?
No,
Okay,
that's in the planning literature.
okay, so we can take that opinion as we may, okay. About the particular suitability, how is this more particularly suited than, say, a photo studio or any other small office?
We're not proposing that here.
It's still a question.
Yep.
It's still a question.
Not testifying as to a photo studio, so.
We had testimony about a bed and breakfast. If we approve this, will she come in tomorrow for a bed and breakfast? And
Anyone can apply for anything, and they have to come to this board, and they have to make the proofs.
Okay, but
to
I
show that there's
I
particular.
believe Cheryl still has.
Yeah,
In my mind, particular suitability, there has to be something about this piece of land that makes it particularly suitable for the yoga studio. And it's not gelling in my mind how this land is more suitable for a yoga studio than, say, any small office or any small studio.
Well, as a yoga studio, this is something that emphasizes tranquility and serenity. So being in a quiet setting is something that would help the yoga studio and would make this property particularly suitable for that. In addition to that, this is a mixed-use property, so there's a residence behind it. The residential-looking cottage in front of it is going to be converted to that studio. So it's going to look residential from the outside. It's going to be a low-impact use with X number of people, as the board has discussed, 16 during the week and 28 on the weekend. So that's a fairly low impact and a managed number, unlike, as you were saying before, a photo studio, which is a retail use, which means anybody can come in at any time. Instead, this is a use that has set times, set numbers of people, and I think is something that is suited for a residential type of dwelling.
Okay. Do you happen to know the minimum required lot sizes for the conditional uses, the house of worship, the community pool?
One moment. House of Worship, 11237.
This is R20, what is it, twice?
It's either 40,000 or
It's
60,000.
it's either, yeah.
Okay, all right.
We're well over.
Okay. I don't have any further questions.
Did you mention,
Any other
somebody
questions?
say community pool is a permitted use?
It's a conditional permitted use, I think. That's one of those things we never defined in the ordinance. It's Pat's fault. He didn't define.
All right, if there are no further board questions on this, we have right now two immediate things. Open to the public, we'll be opening to the public to question the planner on his testimony. Following that, you'll have your opportunity to make your statement. That's two separate things, however. You have something that you want to add?
Mark, that was membership swimming pools,
Oh, gotcha. Okay.
community residences.
That's the Cedar Grove.
Right.
Yeah.
All right, if there are no further board questions, then we will open to the public.
Let me just
For-
clarify for myself one thing.
All right,
Well, how would this, I have heard spot zoning. How does this, what is spot zoning? Could this be considered spot zoning?
Spot zoning occurs when a governing body zones a particular piece of property, typically a single piece of property, into a one zone, and it is surrounded by other zones. Sometimes it's a negative, sometimes it's not. It depends upon the particulars of it.
Could this go to the planning board?
No, because it's not an allowed use. That's why we're here. The yoga studio is not allowed.
It's the exception.
Right.
Okay.
That's why we need to prove the special reasons.
okay, we're still asking questions. You get your chance to make a statement after this session. Let's have your name and question away.
Yes, I'm Liz Chase. I live at 49 Laurel Avenue. And I have a question for this gentleman who testified that
Please
there
make
was-
sure you get a little closer.
that there was,
You hear that? You're a gentleman now.
thank you, that the current location of the yoga studio had a restaurant on one side of it and a rental center on the other. And as a matter of fact, have you been there to see that location?
Not of late. I was there early on in this process, but not lately,
Well,
no.
There is no restaurant on one side of it and has not been for quite a while.
Yeah.
There's a nail salon next to it. It's been there for quite a few years.
Yes, I agree.
Okay, so.
And the restaurant's on the other side.
So that, well, yes, so it is not directly next to the yoga studio. And I wondered how, after 17 years at that same location, all of a sudden, this is a negative location for them.
That's not an appropriate question for this witness.
Remember,
Well, he's the one
we're
that
questioning
testified that-
his testimony.
Yes, and he was the one that testified that it was better move for them to be at the location.
Well, I don't think he testified it's going to be a better move. He testified that that location was an appropriate location. They're two separate issues.
I repeated the testimony of the owner who was here and can substantiate that if you like, Chairman.
When I,
Well, wait a
No, no.
minute. No, we're not,
Very well.
We're questioning the planner right now.
Okay.
There should not
Well-
be a need for you to give that input.
Okay, I have a few
That was
other
the basis of the
questions
testimony.
for the planner. You mentioned that there would be no commercial appearance with your plan visible from the, on the property, the way it was going to be developed. It was going to look just like a residence, and there'd be nothing showing that would make it look like a commercial location, when it's going to have a 28-car parking lot with a blacktop. How does that not look commercial?
I think that my testimony, ma'am, was that that the revised plan that is currently in front of the board, which is different from the one that first started back in January, is more residential looking than was first proposed. By having the buffer between the parking lot and the adjoining residences to the west that was not proposed before, I think that creates a substantial buffer to the residences in that direction. In addition to that, moving the parking lot so that it is lengthwise to the property, so that when you look up that driveway, you're looking basically down the throat of the parking lot, rather than that a wide expanse, at a very narrow expanse,
So you're
you can only see the first couple of cars.
So you're
So I don't
speaking to
think
the
that if I-
visibility from
Yeah.
Sycamore, I'm sorry. You're speaking only to the visibility from Sycamore. Is that what you were referring to?
The original question concerned the residential appearance of it, and
Yes.
what I'm trying to get at is that, in my opinion, the proposal in front of the board now is more residential looking than what was originally proposed in all ways. From the west, there is now a substantial buffer that is being proposed, so that certainly adds a residential component to it. In addition to that, moving the cars away from the west also enhances the residential uses to the west.
Okay. You said that by changing the position of the parking lot, it meant that the headlights of the cars would be facing the open space, facing the field when they came into the parking lot, rather than the previous plan that was a rectangle that had 2 rows of parking spaces, one facing east and one facing west. Now the cars will all be facing east. I think you made a statement that the headlights would not face west.
Well, I think the
Towards
the
house.
engineer made that statement, not
Okay.
not the planner.
Well,
I repeated it.
you did. You did say
Nonetheless,
that.
that
Yes.
is what's reflected on the plan.
Yeah. When cars are coming into the lot with their headlights on, and they turn into the parking spaces, when they're leaving and they have to back out, then their headlights are not going to be facing west. They will be facing, east, they'll be facing west. They're not
No.
all going to stay the same
No.
position all the time.
No, absolutely not.
And of course, once they park, the headlights are going off.
When
So-
people back out of the space, they'll back out to the north, and then they're going to drive south to the driveway.
Yeah, but their headlights will not be facing east when they're leaving and when they're arriving, only when they park.
I agree.
So and they're only going to take them maybe 20 seconds to park the car and then turn the headlights off. So they're only going to be facing away from people for a very short length of time. The rest of the time, the headlights will be facing towards other houses or the road.
No, they'll be facing north when they come in, which is towards the quarry property,
Mhm.
and south towards the school, the opposite side of the street when they're leaving. And then when they're parked, they'll face towards the east, which is the open space.
I
So
live to
They should not be facing west.
I live to the west,
Okay.
and I will have full view of this parking lot, no matter what is built in between, the height of the fence. And I can show that on a picture that we
Let's
have.
focus on questions,
But-
please.
I also wanted to ask, once this area is zoned commercial, this use variance, if it was zoned commercial, does she have to come to the board with any further improvements that
Yes.
she ever
Yes.
wants to make
Absolutely.
on this?
Absolutely.
And if it's dedicated as, there's a section of it dedicated as open space, that primarily means that no permanent structure can
It
be
means
built on it.
nothing can be done. There won't be any tree clearing. There won't be anything allowed on the area. There's a conservation easement that's filed at the county clerk's office that nothing can be done in that area?
Nothing, even a temporary
Nothing?
Uh,
Zero, zip,
pup tent.
nothing?
Even.
They,
Okay.
they won't even be allowed to go in there and clear unless there's an imminent hazard.
Okay, I also, we still are not quite clear on how this open space benefits any of us, because nobody uses and has not used
Okay, you're
that open
moving into
space.
making a statement, which
And
is
that's just
fine
what-
later.
Well, that's my question, was he said that it would benefit. The open space would benefit the people in the surrounding areas.
So you're asking how it
I'm
would
asking
benefit,
how-
that he can answer.
Yes, that's my question. How does it benefit us now, and how will it in the future?
Having open space in a neighborhood enhances property values because open space is seen as a positive for a neighborhood rather than a negative. If, for instance, that property was developed with a number of houses, there would probably be no net effect on the surrounding neighborhood. But having open space is a positive to the neighborhood.
Even though it's not space that the neighborhood residents can use?
Well, they do use it. They see it. They see through it. It's part of the vista of the neighborhood. It's part of the fabric of the neighborhood. So it's used by everybody who surrounds it.
Okay, we're stretching that. I think that's basically all that I wanted to ask right now. I was wondering about the impact, how you define an impact, but if you're not going to go further with that, then I don't have any more questions.
Okay, thank you. And I did neglect to establish a couple ground rules at this point. I'm not going to entertain another question concerning what the benefits of open space are in the neighborhood. We can agree with the answer, we can disagree with it, but we're not going to listen to it until midnight. So as each speaker or questioner goes on, there may be other questions eliminated. You can help us as a board by drawing out facts that may not have been presented before. Does no good to redo everything over and over again. And I'm going to take that prerogative and use it. And in the meantime, you're on.
Okay. Barry Pavlak, 35 Laurel Avenue. I believe you're the first person to testify that actually mentioned the number of sessions that occurred at the current yoga studio. And I think there might have been some confusion based upon a traffic study that suggested there were only a couple of during a day.
What's the question?
The question is, are there not currently 22 sessions during the week?
We presented, and I'll answer, because I presented
We
this
have,
into evidence.
In the testimony, the number of sessions is locked in by the
And it's,
exhibit that's been presented. So
there's 19 for 8, 12, 16, 19 sessions during the weekdays, and actually, on weekends, there are 5, so it's 24.
So there's actually 24.
Yeah.
I had 22, sorry.
Yeah, and this was presented in evidence.
So there are 24 sessions every week at this facility, at the upcoming facility. Next question, you said you visited the site, correct?
Yes.
Did you speak to any of the neighbors?
No.
Was there a reason you didn't speak to any of the neighbors?
No, no one was out when I was around.
Everyone was out.
Back in January and February when I was there, it wasn't very conducive to knocking on doors.
Okay. You said that the statistical average is 10 trips back and forth for a residence. That means a household, 10 trips a day.
The residential site improvement standards of the state of New Jersey specify 10.1 trips for a single-family home.
Is that your personal experience, that's a valid number? Do you live in a house?
I do live in a house.
Do you have 10 trips back and forth every day?
One time, but not anymore.
Okay. Because in this neighborhood of which I am a member, that's not a valid number. The people go to work in the morning and they come home at night.
If you have a question, ask
All
a
right.
question.
we have to take that with a
Okay.
grain of salt too, because that's
Final question.
what you're basing that on.
Final question. You indicated that tranquility and quietness is a very desirable target for the applicant. Is that right?
Yes.
Do you have any idea what the environment we, the neighbors, now have in that neighborhood?
I would hope that it is also tranquil and serene.
Well, it is, and that's exactly my point. Thank you.
Okay, next.
My name is John Heacock. I live at 75 Laurel Avenue. Am I permitted to ask a question to the board?
You're asking questions.
Only to the witness.
My understanding is that business is 7 days a week, 4 sessions during the weekdays, 2 sessions on Saturday, and 1 session on Sunday. Is that correct?
No, that is not correct.
What's correct?
Okay. It is, and let me go over it again once and for all for everybody.
Thank you.
Monday.
This will be it, so let's listen.
Okay.
It's all in print.
Okay.
It's not like they can testify something, one number now, and do something later. It's all here, hard copy evidence.
Okay. The sessions during the week on Monday through Thursday are at 9:30, noon, 5:30, and 7:15. Friday has the 9:30, noon, and 5:30 session, and no session Friday evening at 7:15. Saturday, there are 2 sessions, one at 9 and 11 a.m., and on Sunday, there are 3. They are at 9, 11, and 5 p.m.
Thank you. Okay, my question is, if this variance is granted and the business established at that location, and business is good, and they want to expand their hours, is there any
Have to
reason
come
they
back
can't-
here.
I'm sorry?
They have to come back here.
Okay,
This is the purpose of going through a variance. They're limited. We put the conditions on. The number of classes is the number of classes. They can't be increased.
So this application is for these hours only?
What you hear is what you get, right here. What's presented in evidence is what you may or may not get if it's
Okay, so there
approved.
can't be any changes to those hours?
Unless they come here again and
Unless
you get a
ob-
chance.
Obviously, they come here. Okay, and can I ask a
And that would
question
be
about the traffic?
That would be a public notice hearing.
I'm sorry?
He's not traffic.
That would be a noticed public hearing, so you'd have the right to come back.
Can I ask a question about the traffic?
No.
No? No?
Traffic is.
Depends how he, if it's a negative, if he's asking if it's a negative.
I am Kara Pothier. I live on 8 Shaw Drive. And I understand now what the time limits are and everything they're saying, set time, set people. Who's the burden on to make sure that those are set? That they're not sneaking in 17 people or that an extra class is not?
That is an enforcement responsibility that if, for instance, you as a neighbor tell the township that they're having a class at 3 instead of 5, you will call us, we will enforce it, we'll issue them a violation, we'll issue them a summons, and we can close them
The
down.
burden is on the residents to
Well,
to do
no.
it.
The burden is on.
It's
the
not
muni-
on the board to make sure that
Well,
what
the
they...
board doesn't do enforcement, the township does enforcement. If we find out they're not doing something in accordance with the approval, we take the appropriate action. The burden isn't upon you, but is you as a neighbor are the ones who are going to notice it, so if you notice it and you tell us, we will enforce it. The burden's upon them to follow the rules and regulations.
The other thing, Mr. Chairman, if I may, and I think, what can be done to ensure compliance if that is a concern. Well, first of all, I think we have to notice our patrons of the restrictions that are imposed by the board concerning occupancy. As the board is well aware, and as members of the public are well aware, we have a website. And we can obviously post on our website that the classes are limited and restricted to the numbers that were imposed by the board, so everybody is aware of that, number one. We can also post it at the property. Number two, if there is a concern about enforcement, we will keep daily attendance and have a sign-in sheet at every session, so that, and they would be open to inspection by the board anytime they want to inspect to see who's there and who's not there. So I think in addition to what the neighbors may see, the board can obviously review our daily attendance sheets at each session to make sure we are in fact in compliance.
Okay, thank you. Yes.
Meredith Rogers, 17 Laurel Avenue. Some quick questions. The 10 trips per day, is that a weekend day, a weekday?
Okay, we said we weren't,
We want to discuss that.
Okay, you said average for a household, so.
all right, he's the one that's testified about the 10 trips a day for the residents.
If it's an average daily trip.
Every day.
Per the standards that the state has established
Okay.
and the residential site plan
Okay.
improvement standards. It's in the book.
Okay, so then you also mentioned that the business the open space would increase property values. How does a business decrease property values or affect property values?
It would depend upon the impact of that business,
Meaning, what do you mean?
meaning if there's a positive impact or a negative impact or neutral impact.
Okay. And then you also mentioned, and I quote, benefit to the neighborhood, detriment to public good. Are those subjective terms or are there objective criteria for those things?
They are terms that come from the municipal land use law, which establishes the burden of proof that must be met for this application.
Okay, thank you.
Anyone else for the planner?
Yeah, hi, I'm Matt Dawson, 23 Union Street. You testified briefly about the impact of a residence or multiple residences versus the impact of the business, traffic moving in and out of the community. I was wondering if you considered the case in which vehicles enter via Shaw to get to Sycamore. And considered the impact.
This is not traffic.
That's not a
Right.
planning question.
But he testified about traffic.
No, he didn't.
No, he didn't.
He gave one specific reference to a number. That's a traffic question.
So let me finish the question, please.
No, well, you can't.
But we're
It's
not
on the
dealing
line.
with the traffic with this witness. You can make a statement concerning your
In
concern.
a little bit, you can make any statement you want.
Hopefully in a few minutes. Okay.
Robert Van Zumbush, I'm Vice Chair of the Kingston Village Advisory Committee. I just had a couple of questions. They may be really more to Mark Healy and Vince Dominic than to the planner, but it concerns the development of housing. That would require, would it not, a road, and therefore this would not be a minor subdivision. This would be a plan, which would have to go through the planning board presumably, and therefore there would be an opportunity to place some restrictions which would not be true for a single-family development. Is that not true?
Well, the answer is it would go to the planning board, but if it's a conforming subdivision, there is no ability to put restrictions on it because it's conforming, which they showed they could do.
But it would include the location of the road and screening of the road and things of that sort?
There is no screening of a road required.
For
There's no screening of any road or any houses that are required, no.
Okay.
If
The other thing is,
Let me clarify real quick. If the application was, as Vince said, if it was as of right and they had no variances.
Right.
The board would not have the right to unilaterally impose conditions related to screening, et cetera.
Assuming there are no variances,
If
right.
there were some variances involved, and those variances, if screening related to, reducing the impacts of those variances, then perhaps some screening would be
Right,
involved.
okay, right. The other thing is, it's my understanding that the village district for historic preservation was made to be the same as the National Register. Is that correct?
I don't understand the question.
The Kingston Historic District, Municipal Ordinance District, it's not the same as the National Register District, but my understanding is that the boundaries were made to be the same.
Well, I don't think it has anything to do with this.
No,
That has nothing to do
what
with
I'm
this
getting to.
application.
If that's the case, it was said that this property was not in the historic district. It's listed in the master plan. One of those lots was.
This is in, and let me clarify. This is not in an individual district. It's in the historic district because it's located within 1,000 feet of the canal. It's not in the Kingston Historic District but anything located within 1,000 feet of the canal is under the
I understand-
jurisdiction
I
of the
understand
Historic
that.
Commission. In regard to your thing, really doesn't have anything to do with the jurisdiction of the Historic Commission.
Okay.
It's only under the jurisdiction because it's within 1,000 feet of the canal.
Because
And the
in the-
board has the report from that, from the
Right, in the
Historic
master
Commission.
plan, that property is listed. That's why I brought that up. The lot numbers were changed because there was a subdivision, a consolidation, but that lot is listed in the master plan as being in.
All right, then, we will close this portion to the public. We're going to take a strict 5-minute break, and come back, and then you will have an opportunity.
There you go.
We hopefully only need to hear things once.
You won't. You're on.
And now that we've got the sound back, I think we can do a little better on it. All right, we're open to the public. If you'd like to make a comment concerning the application, come on forward. Again, we need your name, and you will be sworn in.
Elizabeth Romano, a contract to buy 26 Sycamore Place.
Okay, and you solemnly swear or affirm to tell the whole truth, nothing but the truth?
I do.
Try and stay close to the mic. That's
Sorry,
a problem all the time.
So I just wanted to say, I chose this property because of the tranquility of it. And, finding out a week later that there might be a vast parking lot and commercial operation next door was sort of horrifying. The planners stated that open space increases the value of property, but I believe that living next door to a parking lot significantly reduces it, and I object to this plan. Furthermore, I believe that due to the scale of this operation, it is unsuitable for the small scale of that neighborhood. Thank you.
Thank you.
Can I
Oh,
ask
okay.
her a question, since she's been sworn and made statements?
Okay.
Ms. Romano, you're the contract purchaser of Lot 502, is that correct?
I don't know the number, 26 Sycamore. This one.
This property, okay?
Yes.
And it's your testimony that this parking lot is next to your property? Is that how you interpret the
If I
plan?
were buying a home and saw that parking lot, I would say, yes, that's next door to me.
Okay.
Correct.
Okay. And in, if I can find it.
Doesn't help.
And Ms. Romano, I'm going to refer you to Exhibit A12, which was presented into evidence at the last meeting. And at one of the previous meetings, we showed a conforming subdivision plan.
Correct.
And that conforming subdivision plan would show 6 lots or 5 lots. And it would show that you would have a road next to you, a road behind you, with no buffering or no screening. Are you aware of that?
That property was on the market for 2 years. Many developers looked at it and no one bought it. So I'm not worried about that. I believe something else will happen to it. We actually have a plan. Thank you.
All right.
Okay, next. Again, we need to swear you in.
Keith Chase, 49 Laurel Avenue, 39 years.
Solemnly swear to tell the whole truth, nothing but the truth?
I do.
Okay.
I have photos too.
I mean, I can mark them.
We can't see them.
These photos are looking out the second floor of my bedroom window onto the existing fields.
And when did you take them?
I took this one maybe a couple of weeks ago, and this one just this past winter.
Okay.
Maybe this was in March.
Okay.
But these are very recent photos.
Do you want to enter them into the record?
Yes, I would like to.
Okay, so all right, so we can just simply mark that public 1 and public 2. So public 1 will be the winter picture, okay? And then public 2 will be the most recent one you said, right?
Yes.
Okay.
Okay, now we're going to go from that to this.
Okay, and what is that?
This is a Google map of a bird's eye view of our house and the lots surrounding it. And overlaid is their plan to build this 24-car lot, 220-foot parking lot, which is 23 feet off of our property line, and it extends 45 feet back east.
Okay, so aerial view instead of bird's eye, okay, and then who did the overlaying?
The overlay was done by Triangle Repro in Princeton, or Princeton Press on Nassau Street.
Okay. Pete, are you?
I have questions. You indicated that the parking lot is how far from the property line?
23 feet.
How did you measure that?
I went by the measurements on the drawings that the architects had, and the dimensions on the drawings.
Did you hear the testimony of Mr. Ardman that the parking lot would start 44 feet from the property line?
Yes, I did.
Okay,
And I measured from my property line to the back of the lot is 45 feet.
Okay.
Not
Let me just hold you up for just a second. I wasn't actually opening it up to cross them yet. I was just trying. So I'm going to mark that as pre-3. I just wanted you to hear who did the overlay so that you know.
Okay.
I mean, I understand that you. Okay, but go ahead.
So I just took their drawing that they had presented, which was their alternative parking plan, CP1, Exhibit A3. I'm sorry, A13. And I did the overlay with the aerial view to scale.
Okay.
Okay, so it was stated that it was 45 feet from the line, which is not, it is 23 feet from east of the line, and the total distance is 45 feet from my line to the far east of the parking lot. A berm and a fence will not lower noise pollution or light pollution from the residents on Laurel Avenue, which, by the way, those first photographs I showed you are the views from 49 Laurel Avenue, 47 Laurel Avenue, 51 Laurel Avenue, and 53 Laurel Avenue.
Okay, would you take those and
You can.
let the board pass them down while you're testifying?
Sure.
I don't know he's allowed to take that.
Now, is that an additional one? No, that's the same.
That's the same ones he has.
Mr. Chairman, for the record, I'm not going to object to the photographs. I'm going to object to the dimensions that he testified to. He is not an engineer. We have certain testimony from our civil engineer who surveyed the property, who measured the distances, and again, if the board wants to look at his photographs, I have no problem, but I would not concede that his measurements are in fact accurate.
They were your measurements, not my measurements.
Well, I think it's important to get the facts, because you're offering this board testimony. Your testimony, just as theirs, needs to be based on the facts. And, you know, the engineer, and this may not change your opinion, but you're saying that the distance between the property line and the parking lot is going to be 23 feet. But the engineer who prepared the plans is saying that it's what? Can you put Mr. Ardman on the record?
Yeah,
And again, referencing the same CP1, which was entered in exhibit, and you have it as 43 feet. We were at approximately 24 feet in the original plan, and we moved those 18-foot stalls over. So that's where we came up with the 43 feet that scales correctly and is noted on our CP plan.
Okay, so what you're saying is from the property line to the beginning of the pavement for the parking lot, that's a distance of 43 feet. And in that area is going to be a fence, a earthen berm, and some evergreen trees planted on the berm.
Yeah,
That's the testimony, and that is the facts, because that is the plans prepared by the engineer. What I believe may have happened is, perhaps in transposing their plans to the photo, frankly, I think you got it wrong in terms of the distance. That may not change your testimony, but the 44-foot distance is the facts.
So they're
I think
saying
what you may want to do is, based on 44 feet, then offer the board your testimony on what you feel the impact is going to be based on the area, the photos that you took from your second room, bedroom, et cetera. I don't know if 23 feet versus 44 changes your opinion, but that's, I believe, what you need to base your opinion on to the board.
No, it does not change my opinion. Any parking lot built in that field is going to have a negative impact on the village of Kingston and the residents of Kingston. And I see no plan that was presented to the board that would show a positive impact. They only given you speculation and assumptions. We're giving you facts. That's all I have.
Sir, you indicated that you had an opinion that it would render a negative impact, this parking lot, on the village of Kingston. What's the basis of your opinion?
Living in Kingston for 39 years, dealing with the daily traffic that extends from Route 27 all the way down to the Trap Rock entrance almost every single night when people are going home from work. It does not stop before Sycamore. It's in queue all the way down there in the morning and at night.
But your statement was that the parking lot had a negative impact, and I understand your position with regard to the traffic.
It does, because you're adding 15 to 20 more cars 3 times a day, 7 days a week.
That's traffic. That's not the parking lot. The parking lot itself doesn't add cars, does it?
No, but people in the parking lot that park there, they're driving cars, they're going in and out, so that is going to impact them.
And if I were to say to you that the asphalt that was created by 5 or 6 family homes and the 2-car driveways and the roadway would have a far more impervious coverage, that would not have any impact on the village of Kingston?
No, it would not, because it's a residential area. We'd like to keep it a residential area. When Sycamore was extended in 1992. No one in town had a problem with that extension because it was extended as a residential area. And people who had lived in Kingston on Laurel Avenue and other areas purchased houses on Sycamore to stay in that town because of the tranquility in the back.
So is your opinion that the yoga studio would be more, or will be less tranquil than 5 single-family homes?
Yes, it is.
Okay, thank you.
Okay, next.
Good evening.
Name?
My name is Ann Zeman. I'm the chair of the Kingston Village Advisory Committee.
Okay, and your address?
4490 Main Street.
Okay, raise your right hand. You solemnly swear or affirm to tell the whole truth, nothing but the truth?
I do.
Okay.
Good evening, everyone. As I said, my name is Ann Zeman, and I'm the chair of the Kingston Village Advisory Committee, also known as KVAC. The Kingston Village Advisory Committee is jointly approved and appointed by both the Franklin Township and the South Brunswick Township. We were established in order to advocate for good planning and land use in and around Kingston, a village that is bisected and therefore under the planning jurisdiction of 2 different municipalities in 2 different counties. Our specific charter grows out of Kingston's official designation as a village center in New Jersey State Plan. Essentially, this means that the state recognizes Kingston as a village possessing important cultural, natural, and historical assets worth protecting and preserving. The function of KVAC is to advise and assist the townships on matters related to the Village of Kingston and its environs. Our central objectives are the preservation of the historic character of the village and the establishment of a permanent greenbelt of open space around the village. We advise on these matters and utilize the help of our liaisons, Councilman Ted Chase and Planner Mark Healy. We thank you for the opportunity to speak tonight as you consider whether to permit a business to operate at 24 Sycamore in a residential zone that prohibits such uses. KVAC has studied this application closely, especially in the context of Kingston's ordeal overall planning agenda, and we feel that the applicant, Simply Yoga, does not meet the conditions the law says it must in order to grant a use variance by this board. We strongly urge you to deny a variance for this application. As the board knows well, state land use requires a zoning board to make 2 determinations before it can allow a prohibited use. It must consider the so-called positive criteria as well as the negative criteria. In order to meet the first or positive criteria, the board must find that the site is uniquely suited to the proposed use or by its very nature serves the public interest or promotes general welfare. Uniquely suited means what it says. The canoe rental at the DNR Canal in Griggstown is a good example of a location uniquely suited to its purpose. Put it next to water makes more sense than putting it at the closest shopping center a mile away. That kind of unique suitability obviously doesn't apply to this application, nor does the public interest rationale. To meet the public benefit or public interest standard, it is not enough to simply operate a business that meets a market need. It would be hard to find any business that doesn't meet some kind of market need. And if that were all one needed to demonstrate, then by this logic, every business would presumptively meet the public benefit standard, which would render residential zoning restrictions unenforceable and pointless. Public benefit variances are granted for schools, churches, hospitals, and the like. Entities clearly serving a broad public interest. When asked on the public department questionnaire to explain the public benefit of this application, the applicant gave 2 reasons. 1, the yoga studio has been in Kingston for a number of years. 2, this area was a more appropriate location for it. With respect to the first reason, business longevity is certainly an important criterion for a bank loan officer or an investor, but it has no relevance in establishing a broad public benefit. With respect to the second, the application's claim that this is a more appropriate location is simply wrong. Not just because the neighbors don't want a business that generates this much traffic, car traffic, but also because Kingston has a broad interest in the health of our commercial zones and in the success of the Kingston Mall, where Simply Yoga has been operating up until now. Their present location in the mall is, in our view, far more appropriate. It locates business activity where it can be conducted in harmony with the surroundings rather than in conflict with them, and it contributes to the success of a vital commercial center. Simply Yoga makes the Kingston Mall more viable and valuable to the community. Moving the business to a residential zone disrupts the neighborhood while diminishing our commercial district. There is no public benefit to either outcome. The second determination the board must make relates to the so-called negative criterion. The courts have ruled that even applications that can meet the positive criteria must be denied if they are likely to have a negative impact. Here, I think the voices of the neighborhood come through loud and clear, and there is no need to belabor them. In truth, when we undertook our study of this proposal, we were expecting the kind of home-based business that many people try to squeeze through the narrow opening provided by the zoning laws. We were not prepared for the magnitude of this proposed business. Virtually continuous classes from morning through late evening, 7 days a week, more than 40 separate class sessions per week, including regular yoga sessions, weekend advanced sessions, and special instructor training sessions, each generating anywhere from 10 to 30 participants, or 28 now, amounting to hundreds of additional automobile entrances and exits onto Sycamore. A macadam parking lot with 24 striped spaces, fitted with commercial lighting, on an otherwise completely residential street of 15 single-family homes, many with school-aged children, across the street from the Kingston Park and Playground. There are restaurants in the Village Commercial Zone on Main Street that don't generate this kind of traffic, and not a single service business that experiences anything like this volume. Simply Yoga has a great business plan, which makes it a very poor candidate for this location. You've heard how our neighbors who will be directly affected feel about this plan. Speaking for KVAC and our ongoing interest in the long-term planning and preservation efforts that have and continue to make Kingston a better place to live and raise a family, we oppose any project or proposed use that compromises the residential zoning home buyers count on when making the decision to buy a house in Kingston, or threatens to undo the village character we have worked to protect through historic district recognition and preservation. The negative criteria are plain: traffic, congestion, safety issues, lighting, noise, and the disruption of everyday residential expectations and norms. It is for these reasons that the commercial retail is not permitted in a residential zone in Franklin's master plan. It's why Kingston Village Planning Implementation Agenda, developed in coordination with the Franklin planning staff and endorsed by the Franklin Township Council, also restricts commercial uses to Main Street. And it's why the members of the Kingston Village Advisory Commission join our neighbors in opposing this application. Thank you.
Ms. Seaman? Yeah, I have some questions for Ms.
Ma'am, come back, please.
Thank you, Mr. Chairman. Ms. Zeman, you indicated that, first of all, are you familiar with the zoning ordinance of the Township of Franklin?
Relatively. Probably not as well as you.
And you indicated that this property was designated to be in the historic village of Kingston.
It is, yes.
In the zoning ordinance of the Township of Franklin?
In the master plan.
In the master plan, but not in the zoning ordinance.
I'm not sure about the zoning.
Okay. You've
And
never,
also, and also I said planning implementation agenda, which is the document that was made as village center designation.
but the zoning ordinance of the Township of Franklin does not designate this property as being in the historic village of Kingston. Is
I
that
believe
correct?
that's what Mr. Dominic actually
Now,
said.
you also said that your group, which has laudable goals, and I've talked to your group on other occasions, and I appreciate their hard work, would oppose any use on that property that is non-residential in nature. Is that correct? Was that your statement?
We oppose this, and
Well-
more than likely we would, but we look at everything that comes across.
But didn't you make the statement you would oppose any non-residential use on this property?
We oppose this particular.
Did you not make the statement that you oppose any
I don't
non-residential?
believe so.
Okay.
No, I don't believe so.
Okay. And if I decided to put a swim club on that property, which is a permitted conditional use, your group would oppose it?
I don't know the answer to that. I would have to look at it.
Would you oppose a church?
Probably. But I would also oppose the fact that the residents cannot repeat everything, Mr. Chairman, and the lawyer here gets to repeat every single thing for every single person.
I'm asking questions, which I have the right
The
to.
six residential is also hypothetical. You're asking me about the pool, but six residentials is also is hypothetical. You don't know that you're going to do that.
Well, that's
It
some.
is zoned for that, and
Yeah.
and the neighbors are in favor of that.
Okay. And they may get what they wish. Okay, thank you.
Okay.
Okay, just want to remind the people who follow, you have a difficult act to mention something different. So we're looking for additional information in your statements.
Okay, I'll swear you in first. You solemnly swear or affirm to tell the whole truth, nothing but the truth.
I do.
Name and residence, please.
Kara Pothier, H. Shaw Drive. And I just want to go on record, I'm trying to get my kid home. I am opposed to this because of the traffic. I don't mind the residential that you're proposing. I'll put that on record, too. I don't mind a swimming pool. My 6-year-old out there would love it. So I'm just saying that also. You're not scaring me with that. I am concerned about the traffic with regards to the yoga studio, that nothing has been said about Shaw Drive. I live on Shaw Drive. Sycamore, you can, in the mornings when they have classes, you cannot make a left off of Laurel. The only entrance is to Shaw Drive. I don't know if you guys are aware of that or not, but you would have to go to Shaw Drive to get on Sycamore. And then finally, my main point, I just want to say that once you make a residential area, or once you turn this to business, it will never go back to residential. It will forever look like a business. And I think that that's an important thing, that we don't want it to happen, so we need to stop it here. Because a parking lot, no one will buy a house that has parking lot.
Hi, I'm Dr. Beatrix Rumheld-Ham. I am a professor of family medicine.
Just need your address, and then I got to
My
swear you in.
address is 45 Duncan Lane in Skillman. My practice is at 1 Robert Johnson Place.
Okay, raise your right hand. Solemnly swear or affirm to tell the whole truth.
I swear.
Okay.
So I'm testifying on behalf of the yoga studio because as I said, I'm a physician. I teach and practice family medicine in New Brunswick. I have many Franklin residents as my patients and have had for the past 25 years. In addition, I instruct students and residents, so I've taught hundreds of students, thousands of students, hundreds of residents, and have had thousands of patients. What I wanted to say is I have referred many of these patients that had physical problems, sometimes even emotional problems, to yoga studios across the state, really, because it's one of the areas that I have some knowledge in. And this particular yoga studio is the one that I now refer to only. But I have to say the location that they're in is not appropriate, despite of what the lady before said. It is noisy at times. It is not the tranquility that my patients are looking for in a yoga studio. So I've been to many studios in the country. I've been to studios around here, and I've had the feedback from my patients that said, these people are the real deal. They are calm, they are quiet, they are making people's lives better. So when it comes to, excuse me, when it comes to public benefit, I would argue that there's very much a public benefit for this particular studio.
Okay, thank you. Next.
Raise your right hand for me, solemnly swear, tell the whole
I
truth,
solemnly
nothing but
swear.
truth.
My name is Carol Cook. I've been a Franklin Township resident since 1998. I live at 21 Rachel Court in Franklin Park. And during the time that I've lived in Franklin Park, I have considered Simply Yoga to be the greatest cultural asset in Franklin Township. But it is true that the current location has become increasingly inappropriate for what we do. And I'd just like to say something a little more specific about that. It is true that to one side of us there is a nail salon, but it is a shallow space, and the deeper space is where the restaurant abuts on our wall. We share a wall with a noisy restaurant. The restaurant has doubled in size over the last, five years. Many of the people who come there for dinner bring wine and beer, and they enjoy themselves very much over their meals, and they get rowdy. And this comes right through our walls. The nail salon itself frequently has flooding from their sinks where they're doing pedicures. Water seeps through our walls. But perhaps even more of an impingement upon us is the friendly rental. They are very friendly, they're very nice guys, they try to be respectful, but they run power drills and chainsaws and all kinds of other loud tools, and they also emit a lot of fumes of various kinds, and those waft into our studio. So you can imagine that as people are breathing and quieting and trying to do this practice that is therapeutic and contemplative, that this becomes quite a disruption to what they're doing. Another thing I'd like to say is about the kind of unique character, and Dr. Romfeld-Ham testified to that a little bit.
Okay, that's it. She did, and we would like to get new information and not repeat any, as we want to repeat as little as possible.
Okay, I will leave that aside. I would just like to say that I do understand why residents of the neighborhood would be concerned about a change. Things are likely to change in any case because there will undoubtedly be some kind of development there. I think that there is a great benefit to the neighborhood. I don't expect them to see that now, but it will be a very attractive property, well-maintained. The people there are quiet, respectful people. There are not people who are going to be driving fast in and out. These are people who are going to be very concerned about maintaining the very tranquil zone for which we hope to move there. We want the buffer around us. We want to preserve that for the people in the neighborhood. And the people in the neighborhood will have the opportunity, if they want to take it, of being able to walk to yoga classes. So I do believe that it offers a great benefit to the neighborhood itself. Thank you.
Okay, thank you. Next.
Raise your right hand and solemnly swear to tell the whole truth, nothing but the truth.
I do.
Okay, your name and address.
And I'm Liz Chase at 49 Laurel Avenue. And first, I want to thank the board for allowing me to speak to the concerns of the residents on the east side of Laurel Avenue, whose property lines adjoin those of the west side of 24 Sycamore. There are 4 homes along that side of the property dating from 1850 through 1929 that share backyards. Our homes are not visible from Sycamore Street, but are closer to the proposed yoga studio parking lot than those that are. I have lived at 49 Laurel for 46 years, and as the oldest member of our little social backyard oasis, I feel obligated to describe our way of life. The other homeowners in our group have lived in their homes for 33 years, 30 years, and 15 years, respectively. Each of our houses faces the very busy Laurel Avenue, so we have all, over time, extended the rear of our houses and yards to take advantage of the pastoral setting to the east of us. Weekends are a tranquil time for us, with the break from daily commuters making our rear properties a sanctuary. In 1999, a few families got together and purchased a strip of property to the east of the Goki property, which is now 24 Sycamore, from the estate of Arthur Stott, who originally owned all of the lands to the east of Laurel Avenue. And we asked to have the township maintain that as open space. At the time, the township praised us for our actions. In warm weather, we use our open space property for picnics and games and dog walking and general get-togethers. We are a close-knit community of caring individuals who are passionate about maintaining the tranquility that has induced us to live here all these years, many of us retirees that have not left the area for that very reason. We value our weekend and evening way of life in a small village environment. This is a rarity in this day and age, and we have always felt blessed by our isolation away from the Main Street businesses and associated traffic. Having a 7-day-a-week, all-day business next to us would compromise our solitude. This would be especially noticeable in the warm months when we are all outdoors and have our windows open. The proposed yoga studio parking facilities and constant commotion of clients coming and going, unless they're going to just have their cars ease in with the engines off, would be disruptive to all that we have enjoyed about our neighborhood. Thank you very much for all of you who have
Okay,
been so
thank you. Next.
for being so devoted to our community concerns.
Okay, thank you.
Mr. Thomas, please.
Yep.
If I may. Ms. Chase, you live on
49 Laurel.
49 Laurel Avenue. Your property does not abut the subject property, is that correct?
It does. We own a piece of land, the strip of property I just mentioned that we bought in 1999. Yeah, we had a picture up here of it. I don't know where that picture went that my husband had blown up. No, that's not ours.
No.
Is this over here?
I
Is
think it's
this-
over here, the one that we
Excuse
had
me.
made.
I'm going to refer you to the aerial photograph, which is A10. This is our property. Okay, that property is not on the same lot as your house, is that correct? That is a separate,
We purchased that, excuse me, we purchased
Okay.
that property. It belongs to us, a few of our neighbors together
It-
jointly as open space, but we use it right up to the property line.
okay, I understand that, but this property is a separate lot from the lot upon which your residence is located.
Correct, but our
Okay.
name is also on that property, on the
I-
title.
I'm not disputing
Yeah.
that. And do you know what the width of that lot is?
Not offhand.
And can you point out on this photograph where your house is? Okay. Your house is up closer to Laurel Avenue. Okay. Very close to Laurel
Very
Avenue.
close to Laurel
Okay.
Avenue.
So between your house, there's your backyard, then this open lot, and then the
Correct.
subject property. Okay. And that lot is shared by you and your neighbor to...
4 homes.
Further, what would be to the west, I would guess. Okay. The property here on the, next to the subject property on Sycamore, that has a house and an outbuilding, is that correct?
That's correct.
Now, that's not owned by you.
No.
Do you know who owns that property?
I believe Celeste.
Okay. That's Ms. Twomley or something by that name?
Yes,
Okay.
that's correct.
Okay. And she owns basically the property that is fronting on Sycamore and that runs about halfway back, or maybe even 3/4 of the way back to our property. Is that correct? Halfway back. Okay. Okay, thank you.
This young lady owns the,
I understand. Thank you.
okay? You're welcome.
Okay, thank you.
Good evening. If you raise your right hand for me, solemnly swear Affirm, tell the whole truth, nothing but the truth?
I do.
Name and residence, please.
My name is Kathy Pavelak. I live at 35 Laurel Avenue. I'm also a Franklin Township member of the Kingston Village Advisory Committee. And I want to just say briefly, we're a neighborhood of families, and we haven't yet discussed the children in the neighborhood. There are 21 children in what we call the neighborhood, Sycamore, Union, Shaw, and Laurel. There are 21 children under the age of 12. 18 of those children are under the age of 8. They ride their bikes, they play in the park, they walk to each other's houses, they walk to and from the bus stop, and they deserve to do so in peace and safety without the threat of even more traffic in the neighborhood. 32 cars might not be significant to a traffic engineer, but they're significant when Sam is running around and all the other kids in the neighborhood are running around and playing and doing the stuff that kids do. This use variance would really change our neighborhood forever. If this happens, there's no going back, because once there is a parking lot in our neighborhood, it will forevermore be commercial, regardless of if there's a piece of paper in Vince's office that says that it's R20, it will in fact not be R20, because no one will ever buy a house with a 24-car parking lot. I think that we really have shown the board, by our numbers and our determination, that the residents of this neighborhood are united in our opposition to the granting of a use variance for the 24 Sycamore property. As residents of Franklin Township, we look to you, the zoning board, to protect us from the erosion of our way of life. This application speaks directly to why we have zoning laws and zoning boards in the first place. This is why you are here, to protect the neighborhoods and residents of Franklin Township and to protect our way of life. To try to characterize a commercial development as being insignificant defies logic. We are a neighborhood of families with homes that we have worked decades to build and improve. We are a lovely, peaceful neighborhood because we made it that way. This development project will irreparably rend the fabric of our community, and we ask you, the members of the board, to protect us from that and to help us keep the historic village of Kingston and the township of Franklin a beautiful, peaceful place to live. Thank you.
Sir, solemnly swear or affirm to tell the whole truth, nothing but the truth?
I do.
Okay, name and address.
Jim Diaforley from 32 Sycamore. I'm just going to move this so I don't have to bend over. I'm not opposed to yoga. I'm not opposed to business. I'm very much a capitalist. But I am strongly opposed to this use variance. And that's just to get back, to what we came here for, what this is all about, is changing the use variance. Whether it's a yoga studio, whether it's anything else, it's a change. Businesses come and go. Who knows what could possibly be there down the road? The community, we're going to be stuck with a business. That's what I'm opposed to. The other thing that throughout this entire session kept coming up, and it was, quite frankly, a little annoying, the leveraging and the really condescending way of talking about, if this doesn't go through, they could put 5, 6 houses in. I would welcome that. And we would be the most impact. It's residential. And I would say to the owner or future owner, go for it. Whatever you would like to put in there, it fits within the zoning, again, we would be more impacted than my fellow neighbors down on Laurel, because we back right up to that property. Who knows? Could increase the property value. But I didn't think that that was appropriate for the record, okay? Been a lifelong resident of this township. Grew up in Greekstown, lived in Kingston for 22 years. So we just haven't popped into Kingston to take advantage of the new development in the back 22 years ago. So in closing, I would be disappointed, very much disappointed if this passes. Thank you.
Sir, if you raise your right hand for me, solemnly swear or affirm to tell the whole truth.
I do.
And your name and address?
My name is Greg Ham. My address is 45 Duncan Lane in Skillman. I'm a biotechnology executive and consultant, so I am in business. I am also, since January, a new teacher at the yoga studio, and I'd like to just speak to one issue which keeps coming up, which is the characterization of this as a commercial activity, which I understand technically it is. But this is not like a McDonald's or a bank or anything like that. It's a very small and peaceful activity. I can tell you, being a teacher of one of the morning sessions that people have characterized as sort of vast, I usually have between 2 and 4 students who show up, and I know that's the case for many of the other sessions as well. These are, by and large, people who are interested in quiet. They do not drive their cars fast. They do not make a lot of noise. When you go in for a yoga session, you come out and the last thing you want to do is be loud and disruptive and drive fast and those sorts of things. So I just wanted to try and give a personal testimony that the nature of this, quote, business, unquote, is very different from what you think when you think, oh, a commercial activity. And I think in that sense, it is one that I think it's lovely to hear from these people about the way of life. And I just wanted to speak a little bit to the way of life of this particular studio. And finally, I would just like to say that it is a very unique place. There are tons of yoga studios. This is the only one that I have found that would induce someone like me to ever think of becoming a yoga teacher. And it's because of the particular tranquil nature. It's not like gym yoga. It's not like a retro fitness, as people said. So that's my testimony. Thank you very much.
Thank you.
Hello, my name's David Thurn. I'm a Franklin Township resident, 21 Rachel Court in Franklin Park.
Solemnly swear to tell the whole truth, nothing but the truth?
Yes, I do.
Okay.
I'd like to make 2 points. Many of the reasons for our wish to move have been stated. You know, just to say again, the present location has become increasingly inappropriate, and a couple of the things that have not been mentioned is, apart from the occasional fuel spillages next door from the rental shop, occasionally a pickup truck will be idling right outside our door waiting to pick up equipment, and the fumes from the trucks kind of fill the studio. We also have cigarette smoke that come into the studio from patrons of the Sushi Palace who sometimes linger out front. And I understand the sushi chefs sometimes go out back to smoke as well. So we are attracted to this lovely property precisely because it's more in keeping with the kind of tranquil, serene, peaceful work we do. Second point, the studio's been characterized as a shopping mall business, and of course that is literally true. That's where we've been since 1998 for the last 17 years. But as Greg stated, you know, we're not a hoagie shop or a dollar store. We're a teaching facility, and what we offer is the teaching of yoga. And people come to the studio for their physical health, for their emotional health, and I well understand the benefits of yoga for emotional health because I'm a psychotherapist and I have often recommended that my patients undertake a practice of yoga. Our students come for the quality of teaching and for the community. And so I'd just like to make clear that while we're a business, yes, people pay for classes when they come to yoga classes. But our identity is about these other things: physical health, emotional well-being, quality of teaching, and wonderful community that is, I think, marked by warmth, openness, and a lot of integrity. Thank you.
Okay. Next.
Raise your right hand for me. Do you solemnly swear to tell the whole truth, nothing but the truth?
I do. Kelly Probst, 2 Union Street, Kingston. The property's beautiful, and I could see why a business or practice of yoga would be attracted to it. If I were to do yoga, I would want to go to a place like that. That said, that's what worries me. It will be so unique, and I know the owner has talked about the competition of other yoga studios all around. That your two-person classes are going to go to 4, 5, 6, 13, the max. That business is going to grow, and that concerns me as a resident and a mother of two of the little boys that run. There's no sidewalks there. I don't know if anybody's mentioned that. We have people walking their dogs. We have children riding their bikes. I have kids randomly running across the street at the park. One extra car is too much for me. And I wish you luck somewhere else. It's a beautiful spot. But I oppose. I would like to keep the quiet nature of my neighborhood. And I just know if a studio like this is built, it will become very popular. The property's beautiful.
Thank you. Next.
John Heacock, 75 Laurel Avenue.
You swear to tell the whole truth, nothing but the truth?
I'm sorry?
Do you swear to tell the whole truth, sir?
Yes. Okay, my concern is, well, basically, I got no problem with yoga. I have a friend of mine, obviously my age, who's benefit greatly from yoga. It's a fine thing. My concern is we cannot let this variance be changed. We cannot allow a commercial business in a residential area in our town. We can't tolerate it, if you don't mind me using that word. I'm sorry to sound a little harsh, but I've lived in this town since the late 1940s, and this town has been as it is now, and we have a residential area. If they want to bring homes in, that's fine. It's called residential. That's not a problem. But if we have a commercial business allowed to start, it'll be commercial area forever, and anything can come in there later if the yoga studio decides to move again. Thank you.
Right. This is not your second trip, right?
No.
Okay.
No, I'm following the rules.
Multiple hearings. Yep.
Solemnly swear to tell the whole truth, nothing but the truth?
I swear.
Okay.
And not to repeat about Meredith Rogers, 17 Laurel Avenue. Not to repeat what anybody else said, I just want to state for the record, I agree with what all of my fellow residents have said. We do not want a business in our neighborhood. We would rather have the houses. Thank you.
Thank you.
My name's Pam Diaforley, 32 Sycamore Place, Kingston.
And you solemnly swear to tell the whole truth?
I do.
Okay.
I just want to go on record that I oppose this proposal. I have lived, I think I'm the longest standing resident on Sycamore Place. My family moved there when I was in high school in 1968, and it actually was not even paved, or part of it wasn't paved. It was a gravel road. And it has been a very unique experience. I've raised my kids on that street, and now my 3 grandkids ride their bikes, run, play across that street. And so, as other neighbors have mentioned, I think yoga is wonderful, but this is a residential neighborhood, and we would like to keep it that way. Thank you for listening.
Thank you.
Barry Pavlak, 35 Laurel Avenue.
Swear to tell the whole truth, sir?
I do. I just want to reiterate what has been said before from the neighborhood. There are plenty of other places to set up a business, plenty of other quiet places to set up a business. There are very few residential areas like our residential area. It's what made it attractive, I'm sure, at the first point for the applicant. But it's a residential area and it should remain so. Thank you.
Thank you. Next.
Teresa Russo, 45 Laurel. I just
And-
would like to be on record.
Let me swear you in.
Oh, sorry.
I'm getting tired of it myself. You solemnly swear to tell the whole truth?
I swear to God I do.
Okay.
I have lived in Kingston for 73 years. I've been on Laurel approximately 42. It's a quiet little neighborhood except for the traffic, which we accept. And I really opposed to this studio being in my backyard. Thank you.
Good evening.
Hello.
Raise your right hand for me. Solemnly swear to tell the whole truth.
Yes, I do.
Name and address, please.
Laurel Kane, 53 Laurel Avenue. It's a coincidence. I oppose this. My property would have your parking lot right behind my land. We have a dog. You talk about tranquility. When all those people come into the parking lot, he will bark. And when they leave, he will bark. It will not be tranquil. I'm sorry. That's the way it is. It's our yard. We're allowed to have our dog in our yard. He will bark. So you will not have tranquility. We have nieces and nephews who come over to our house quite frequently. They play in our backyard. We don't want a parking lot behind our backyard. I oppose this. Thank you.
Good evening. You raise your right hand.
I swear. Okay.
And where?
Tell the truth. And I swear his wife is right.
Thank you.
Okay. My name is Serene Hashim again, and I live 47 Laurel Avenue. And tell you the truth, starting today, I need to change my name because Serene came from Serenity. And I don't think so. After the yoga center come to my backyard, I'm not going to be serene or serenity at all. I love yoga. I like sports. I am 48 years old. My son is 23 years old. And I'm in shape without having yoga. I garden. I sit in my garden, which is exactly next to your parking lot. This is what I do after I come from my teaching in the high school. This is my therapy. And I really want to keep it this way. So if you like yoga, found somewhere serenity other than my backyard. I love my serenity, so I don't want to change my name actually too. Thanks, bye.
Good evening. Solemnly
I
swear.
swear, Oscar Schofield, co-owner of the proposed yoga studio, and couldn't testify earlier. I was at sea in Antarctica. I'm going to be speaking more as just a student very quickly. I'm not a teacher. I'm a student, and I can just speak therapeutically. I got involved simply because I had some very severe injuries that yoga helped. And the advantage of the studio is that the classes are small, and that's actually been why we've had loyal students the whole time. So that's the character we're trying to keep, and I thank you for your time.
Thank you.
Good evening.
Good evening.
Raise your right hand for me. Solemnly swear to tell the whole truth.
I do.
Very good. And your name and address, please.
Libby Ranny, 65 Laurel. And I haven't come to any of the previous meetings, but I certainly got it all laid out tonight. It seems to me it's a zoning issue and a change in zoning. And
I happen to do yoga. I like yoga. It's not pro-yoga, con yoga. It's zoning changes, and I'm opposed to it. Zoning is to preserve neighborhoods. It's exactly what it's there for. It's been said before, but I concur. Thank you.
Solemnly swear affirm to tell the whole truth?
I do.
Okay.
Amy Andrega, 39 Baldwin Street, Pennington. And I've been a student at Simply Yoga for 10 years now, and I just kind of object to the way the studio's been painted. It is a small, close-knit community of dedicated students of yoga, and I don't think that a barking dog can compare with the noise that we put up with now from Friendly Rental, in particular during classes, the power drills and the other things that go on. And I appreciate the concerns of the community, but we ourselves are a community, and I don't think that that's been properly represented tonight. And I just wanted to say that. Thank you.
I'm Lori Josso Martin. I am a teacher at Simply Yoga, and
You're going to be sworn
I
in?
swear, yeah.
Thank you.
And I just wanted to say I understand the concerns, but I'm a mother of two, and there's no way we would ever jeopardize anybody. Like, we would drive totally safe. We're not that type of people. We would not be racing in and racing out. And it's a loving, supportive community that I just feel like once they would get to know us, they would change their mind. It might just bring some blessing into their neighborhood.
Good evening, sir. Solemnly swear affirm to tell the whole truth?
I do. Joe Kane, 51 Laurel Avenue. I've been a resident of Kingston all my life. I've been a homeowner there for 30 years. My backyard is adjoining their property, and I'm just going on record to saying that I oppose this use variance. Thank you.
Good evening.
Hi, I'm Karen Linder.
Solemnly swear to tell the whole truth?
I do.
All right.
I thank you for the opportunity to talk to you today. I have been a resident of Kingston for 30 years, and unlike most of these people, I live on the South Brunswick side of town. You can see, and I know this from living here, that the people in Kingston are more engaged than any place else that I've ever lived, and they're really not shy about voicing their opposition to this proposal. This is not the first time that we've opposed granting such a variance. In 2008, as part of the Kingston Village Advisory Commission, or KVAC, I helped to lead a successful fight against a similar attempt to site a business on a residential street on the South Brunswick side of Kingston. The owners and their architects and planners have certainly made a good case for wanting to move out of the Kingston Mall, although we're very happy to have them being anchors at the Kingston Mall. But I don't think that the strong case has been made for them to move into a residential neighborhood. There have been a lot of changes that have been proposed to try and modify lighting, parking, et cetera. But I think that all of these proposed modifications that were done to make the proposal more palatable are really just kind of putting lipstick on the pig. They've really failed to establish the two key findings that New Jersey land use requires boards to make in order to allow a prohibited use. And we've been through, you know, sort of a lot of the prohibited and allowed uses already. But I wanted to just sort of comment a little bit on, you know, kind of the assertion on the part of the planner that this business was inherently beneficial.
I don't think he said that. He didn't say that.
No, well, you know.
I wouldn't have let him say that.
Okay, okay. But, you know, that.
We could have stopped him.
All right. But, you know, that it was uniquely suited for the place in part because it was peaceful and health-related. But if that is, sort of one of the factors that should allow a business to go into a residential neighborhood, then any health-related business should be allowed
Okay, I
in.
think
And that's
we
not
did-
really something I want to
We
see.
did hear that, so you
Yes.
seem to be similarly reflecting the views of the other lady from the organization.
KVAC, okay.
KVAC.
Well,
If you could
I will.
add some different things, that would be fine.
Okay.
Well, I think that last point, though, I think was unique, and that her point is, could you repeat that last point? That it basically, you said that
That
if
essentially, if you make the case that a health-related business or something that is sort of peacefully oriented and quiet should be allowed into a neighborhood just because of that, as, something that makes them uniquely suited to move into a neighborhood, that's a dangerous precedent to actually establish. Thank you.
All right.
Okay, I believe we're down to the last two people.
Sir, if you raise your right hand, you solemnly swear to tell the whole truth?
I swear to.
Okay.
My name is James Hook. I live at 65 Woodside Lane in Princeton. I've been going to the Simply Yoga for about 8 years for my health because I have numbers of issues. I'd just like to affirm what people have said about the current situation, and if the first speaker from KVAC would like to come to a class, especially in a warm day when friendly yoga, friendly rentals is quite active. It is not a good location for that. And I think we would be a different sort of health-related facility. Not all of them, as someone suggested, retro fitness would not be, they're health-related, and they certainly do people good. I'm a member there too. But yoga is much more peaceful, tranquil. Anyway, thank you.
Thank you.
Yes. Do you solemnly swear or affirm to tell the whole truth?
I swear. My name is Philomena Russo, 34 Sycamore Place. Been a resident for 22 years, raised my children there. Feel that I just want to go on record for saying I'm opposed to the change in the use variance. And I know that you have made an amazing number of concessions to make everyone on the board open to the change in this variance. And our concession as a group of neighbors will be that we will accept anything else you want to put there other than a business. Thank you.
My name is Al Russo, 34 Sycamore.
And you swear to tell the truth, sir?
Yes, I do.
Okay.
I just want to go on record as well, saying that we are the home that abuts that open field, and we do not want a commercial variance issued. For all the time and money spent on this issue, at the end of the day, they really have offered no true compelling reason for this variance, and I would just urge you to vote against it. Thank you.
Robert von Zumbush, Vice Chair of the Kingston Village Advisory Committee.
And you solemnly swear to tell the
I
truth,
do.
sir?
I just wanted to say that there are numerous reasons given why the present location of Simply Yoga does not work for Simply Yoga. That does not mean, though, that it works in the neighborhood. And I think that's very clear. I think the Kingston Village Advisory Committee has tried to be very open about this. We had the Simply Yoga come in and make a presentation with its architect, and we listened. We also listened to the neighbors. And we feel strongly that the plan that is embodied in our planning implementation agenda and is reflected in the zoning should be preserved in this case. And as Karen Linder mentioned, we've also fought similar things on South Brunswick too. It's not just in Franklin Township. Thank you very much.
Good evening, sir.
Good evening. I do.
Okay.
Rod DeLeo, 28 Sycamore.
I just want to say that I'm opposed to this change. And to all the students and the teachers who are coming here to say how bad it is to be there and that the restaurant is bad and then the tool rentals, you guys are being the restaurant and the tool rental coming to our place. And we don't want that. Thank you.
Hi, my name's Kathy Kish. I live at 27 Union Street. I live directly across the street from the proposed yoga studio. And I swear to tell the truth.
Yes.
And I just want to go on record as being opposed to the change of the variance.
Thank you.
Chris Pollard, 39 Laurel Avenue.
Swear to tell the truth, sir.
I do. Just like to go on record to say that as benign a use as a yoga studio may be, it is still changing the use of the property from a residential to a commercial, and therefore I feel we should oppose it, and I'd ask you to consider that carefully in your decision tonight. Thank you.
Okay, we will close that part of the meeting, and that then goes back into your court.
Thank you, Mr. Chairman, members of the board. We've spent a lot of time reviewing this application. I do thank the board for their time, for their questions. I also thank the members of the public. I've been here in many meetings where there was a lot of discussion, and the discussion was contentious. The neighbors expressed their views. We appreciate their views. And the board has a very difficult decision. And I want to start out by saying that the reason we point out the potential uses on that property is not to leverage or not to threaten, but to paint a picture. Because oftentimes when an application is presented, people who live around a project see a yoga studio or a school or something, a church, versus what's there now, which is basically not much. And that's not going to stay the same. And I can't tell you that there will be 5 houses there or 6 houses. I can't tell you that there's going to be a school there or a membership swim club there. But they are all things that are permitted in the zone. And I think in looking and analyzing this application, you have to weigh that also. And for these people here, it's an emotional issue. They live there. They live in that community. And sometimes emotions are good, and sometimes they may cloud some of their opinions. And I think the board has to try to be as objective and consider the ramifications of a 5-lot subdivision. Consider that houses that now have a front yard on Sycamore will now have a front yard on a to-be unnamed street. Consider that if those houses on Sycamore decide that they want to do something as far as adding on to their houses or changing something, it may be more difficult because they front on 2 frontages. You also have to consider, and I understand the concerns of the people on Laurel Avenue, but if you look at the maps and you look at the distances, and they talk about our parking lot being in their backyard. Well, quite frankly, the parking lot is in our backyard. And our backyard is basically 43 feet from the property line. And if you look at the map that was put into evidence, in addition to the 43 feet, there is significant open space between our property line and 2 of the adjoining properties. Ironically, the property that fronts on Sycamore adjacent to us, which is probably the most impacted property, That property owner wasn't here at any of the meetings, was not here. And that's the property that's most impacted. I think that, you know, the board in looking at this, and I think there's ample testimony by the professionals to support the grant of this variance. I think the site is particularly suited. I think there are benefits. And while people may laugh or dismiss 2.2 acres of open space, I think it's important. And if you look at the cases, when you look at the cases, when you're asking for a variance, the cases talk about sometimes the word no significant impact. Any development on this site will have an impact, whether it's 5 houses, whether it's a swim club, whether it's a church, whether it's a school, whether it's an antenna for communications, which is permitted, will have an impact. The question is, objectively, is this impact significant enough to really turn the table against this application as compared to what is permitted there? We have made sessions. The purpose of our wanting to be there is to continue to be part of the community. We've been there, at least in Kingston, for the last 17, 18 years. I don't think there's any question in hearing the testimony of the applicant and the members that go to the facility that the use is a benign use. And while the neighbors are concerned that if we disappear, something else will come in there that will have a more detrimental impact, that is not the case, because any change of use, whatever it is, has to come back to this board. And this board can say no to any other use. This board is reviewing one application for one use with the parameters and conditions that we've agreed to. And that's what they have to look at. And the issue is, have we made our case for that use? Not the fact that it may be something else in the future, because it may never be anything else in the future. What we have to look at is what is before you. And it is a difficult decision. This is not an easy application. And I think the board has to take the emotion out of the application and look at the testimony. We have provided significant buffers between our property and the adjoining properties. There is significant distances between the properties. And I think it's also important to remember that, you know, people say, I welcome a residential neighbor behind me. Until that residential neighbor, who is now has no fences, no screening, no buffering, has their dog barking at 2 o'clock in the morning when the other dog starts barking, and all of a sudden it's not so quiet and peaceful behind me. There was also testimony by one of the neighbors that, you know, they don't want to see lights on the adjoining property. If a residential development comes in and a 2-story house, which is permitted, goes behind the houses on Laurel Avenue, they certainly will have lights. They will have headlights in cars pulling into their driveways towards Laurel Avenue. So this is not a situation where we have an application that is, in our opinion, going to make that neighborhood significantly worse or in any way worse. And I think, as Mr. O'Brien pointed out, you have to look at this site, you have to look at what we're proposing, because that's the nature of this application. It is not a retrofit, this is not some of these other things, and you do have to look at the permitted uses and say, does this site make sense for this use? Do I advocate commercial uses all over residential zones? No. And this board shouldn't. But you have to look at this particular application, this particular property, with the testimony that was presented. And I believe that we have met our burden of proof, and I could go on and give you a bunch of the reasons why, but given the lateness of the hour, I will at this point say, I think we've established our burden of proof. I think that the things that we have provided to the neighbors are a benefit. And I think if you weigh that benefit as opposed to some of the permitted uses in the zone, I think this is a supportable variance application. And I guarantee you that if a year from now or 2 years from now, somebody comes in here with a church, with a school, with a swim club, we're going to see, which are permitted conditional uses, these same people are going to be here. And I dare say, having handled applications for houses of worship and and schools, that the traffic that may be created by those applications would be significantly greater, and your ability to say no would be significantly diminished because there are certain rights that these uses have. So I know the board has a difficult decision. It's not just we don't want it, but maybe you want it because it may be better than what may come down the road. And I do think that we've established enough of a legal justification for the grant of the variance. I do thank the board for their time, and I ultimately think I'm going to take all of these meetings and then put them on Netflix and see if we can make some money since we have about 12 hours of testimony. I thank you.
Okay, it's about that time. A couple things before we start. Some of these things are part of the testimony, so I'm not going to I'm going to present them as conditions in terms of if there's an approval. The half hour between class, the cap of 16 during the week, 28 during the weekend, no other activities except yoga. I liked your suggestion to have a sign-in sheet. Makes it easier for everybody. Remaining land is dedicated open space, by the way, of a conservation easement. And then one thing we didn't zero in on, and I guess it's not till it's proper now, the house that's being built is intended to be the residence of the owner.
Of the owner, yeah.
Yes.
Now, I think it's an important issue that some part of ownership actually resides there. In the beginning, I think I recall the testimony of your applicant is that she works in Washington, D.C., so she's not there during the week.
She's not there 5 days a week. She doesn't work in Washington, D.C., but she commutes to Washington, D.C.
That's all right.
Yeah. That answers that question.
Yeah, all I'm concerned about is if the house is there for that purpose.
For one of the owners of the
If
studio.
there's an approval, having the owner residing there goes a long way to taking the responsibility for other conditions.
And the board has the right to impose that condition.
Okay, that all being said, I'm open to the board now, whatever your.
I would like to see the times and the size limitations of the classes be listed on the website, and no tall lighting fixtures except around the parking lot. And except for that, Bob, I think you picked them all up.
Do you want to prohibit a left turn out of that project or not?
I go to the grocery store on Route 27, and I see how those things work. They work as if somebody wants to turn the wrong way, they turn the wrong way. So
Again, that was offered. I just wanted to make sure
Yep,
that you didn't
appreciate
forget
that.
it.
But Bob, do you want any reporting requirements to them? Because they had said that they were going to.
No.
No?
We had with the fence around the dry well, so, right?
Detention basin, yep.
Retention basin, whatever you call it.
Yeah.
Okay.
Boy, you pay attention. I'll tell you what, that's that's a long time ago.
Okay, I just want to make a couple of comments because I'm going to tell you how I'm going to vote. I listened to the testimony very carefully, Peter, very carefully. And before I tell you how I'm going to vote, I just want to indicate that I have no qualms that the applicant is more than honest, and whatever she has said she was going to do, she will do. I have no qualms about that. I was not pleased with the total testimony of the people with the traffic. Even tonight's testimony, it wasn't enough for me to convince. I've lived in this township since 1969, and I know when an area is used to a tranquil area, and especially the Kingston area, which I know very much about, I'm hearing the testimony of all of the residents, and I still believe there is room for this yoga outfit, but not in this area. I'm sorry. So I'm going to vote no.
All right, are we satisfied, let's put it this way, that there are all the proper conditions that anybody wants to?
I think so, yeah.
And then if so, we'll entertain
I so move.
a motion for approval. We
Second.
All right. Is there any further discussion?
Yeah, I would like to say something. I've listened to this application. I marvel at the job that Mr. Lanford does. I'm more impressed with him every time I hear him do a case like this. I also thought that Kevin's testimony was I think the word unique is what comes to mind. But I, in the end, have found that this application meets neither the positive nor the negative criteria that it has to meet in order to be engaged. The question is not whether it's going to be more of a burden on the town to have something that complies with the zoning laws in the space as opposed to something that doesn't comply with the zoning laws. The question is whether does this application, it's not a hardship application, so the property had to be uniquely qualified to support this particular use. And I thought that the first woman who came from HVAC or KVAC said it best, that there's not a situation where this is uniquely qualified. I think it's a great location for something like this, but it's not not uniquely qualified for a place like this, and so I don't think it meets that criteria. And I think that the residents amply demonstrated the negative criteria and how they'll all be affected by this change, by the change in the traffic, by the increased noise from the people coming into and from the classes. And that is not to say that yoga people are noisy. I was very impressed by the tranquil nature of everyone that came up and spoke tonight. But I just, no matter how quiet you are, it's going to be it's going to change what's going on in Kingston, and since there is a use for that property that fits, as was amply demonstrated, that fits within the that particular property, I think that I'm going to vote no for this application.
Any other discussion?
I move for a vote.
I just wanted to say something about the groups that are here from the yoga studio and from the community. I've been on the board a long time, and I haven't seen this thoughtfulness and self-expression and freedom to say whatever's there to be said. And it was very extraordinary. And I appreciate the opportunity to have been here for 4 sessions and test our zoning, and we'll see how it goes.
Any other discussion? Call the board.
Mr. McCracken?
No.
Mr. Rich?
Yes.
Mr. Shepherd?
No.
Mr. Reese?
Yes.
Mr. Rosenthal?
No.
Mr. Caldwell?
I have listened to both sides of this, and I really appreciate the fact that Simply Yoga is not in the place where they need to be now. I've also listened to the neighbors and the folks that live in the neighborhood, and one of the things that, for me, is that they said that they don't want to have Simply Yoga there, and that they are willing to live with whatever may come in the future. So with that said, I vote no.
Chairman Thomas?
I'm not going to repeat what everybody else said. I agree with a number of the comments, and I would just add that I really don't feel that I've been given a compelling reason to change to grant a variance from the zoning that's in the neighborhood. I think and I want to piggyback with Mr. Coble. Some of the things that may come down the line, may eventually be conditional uses or approved uses or whatever, might even be a little more busy, let's say, but at least, you're dealing with approved uses, so I'm going to vote no.
Motion fails.
Thank you very much.
Motion to adjourn. Meeting adjourned.
Second.